15.
15, my lord. I'm the opposite party in the IA, my lord. I'm paying for 3 weeks time to file my objection, my lord.
Any objections from the,
Consent taken, my lord. I've given the adjournment slip also yesterday.
all right. Item 15 to be listed after 3 weeks.
Much obliged, lord.
On the mention made by Mr. Misra,
My lord.
for the applicant,
Yep, opposite parties, my lord.
for the
Opposite party.
opposite party. It is submitted that consent of the counsel for the respondents are also been taken. Yes.
Much obliged.
May I please, Your Lordship? I beg to mention item number 46. The government said file affidavit. In this case, we are time required for filing affidavit in reply. Lordship.
46.
Lordship.
46 is to be, okay, you want to file reply.
Reply, Lordship.
Item 46 on the request made by Mr.
R.L. Sutia.
R.L. Sutia, counsel for the petitioner, stands deferred for 3 weeks, enabling him to file the rejoinder affidavit to the affidavit filed by the respondents listed on it. Obliged.
May I please? Yes, I need to mention for listing, my lord.
Listing what?
It is matter with regarding dismissal of the petitioner.
Fresh matter, old matter?
The old matter, my lord. It is 2024.
Old matter.
Yes, ma'am.
All right. Next week, it will be monopoly.
On 15, my lord.
15. All right, 15.
Obliged, ma'am.
15 for what? Admission orders what?
Admission.
Admission order.
Obliged, ma'am.
May I please, Lordship, with the consent of the petitioner, I beg to mention item number 14, Lordship.
14.
There is some difficulty on the part of the engaged counsel, which the Mr. DJ Das. He is out of session for some medical reason, Lordship.
Who's for the petitioner?
Petitioner, we have taken the consent, and we have also filed adjournment slip, Lordship.
Your file.
Lordship.
Item 14 as per the
14.
adjournment slip. Circulated matter stands deferred to be listed after 4 weeks.
I'm obliged, Lordship.
May I
Yes.
please, Your Lordship, with the consent of the other side, I beg to mention item number 51.
51.
Yes. Lordship, may I pray to take up this matter after vacation, Lordship,
51. Item 51.
after vacation.
On the request, on the mention made by Ms. R.R. Kakuti, matter stands deferred to be listed after 4 weeks.
Lordship, kindly give it a Lordship.
After 4 weeks, we listed, this is for hearing.
Yes, Lordship.
So it will come after 4 weeks. This is for admission.
Oh, no, wait. It's admission column, Lordship, 51.
Admission. 27th October. Yes.
I seek my lord's kind indulgence to mention a matter. Lordship, this concerns a similarly situated petitioner as the item 63, 64, 65. He is also an ACS officer aggrieved by a discharge order. I pray his case be taken up unlisted
Today,
today, Lordship.
why unlisted? Let it come some other day.
The fresh matter, all
Fresh.
ready, everything.
Have you
is there.
served copies to the other
Yes,
side?
yes, sir.
All right, let us see, bring it.
Great.
But these matters are, I'm informed that this will be through VC.
Yes, Lord.
So we'll have it in the second half.
Yes, Lord.
Okay.
Much-
Lordship, yesterday's that reading entry matter, I have prepared the note and this.
On motion item 1.
Yes.
Hey, Lordship. My lord, this is a
Where is the agreement?
page 24, kindly see.
Arbitration clause
That is page 27.
27.
Starts from 27. There's 21 arbitration GCC clause 25(3).
All right, we'll issue notice.
My lord, Lordship will keep the limitation open, my lord. Because last
Whatever
bill
you
was,
want to object, you object.
my lord,
We are giving you, we are issuing notice, you may file objections.
on the ground, limitation, my lord, because it hits the limitation, man. Why, so Lordship?
You file your objections,
Lord-
raise your objections. Third, counsel for parties issue notice. Returnable 4 weeks, Mr. S. Bora,
For all the respondents.
APS for all the respondents, therefore notices are waived. Extra copies be furnished. Be learned counsel for the respondent within 1 week from today. Respondents may file their objections if any.
I think
Same order,
Same order.
same order.
Well, look, my name is not been spent.
Where is the clause, arbitration clause?
Item 2 is different, higher education.
Not my case.
Where is the clause?
My lord, in this case, I am to file addition affidavit. 1 page is missing, my lord. Just I have noticed.
Counsel for the petitioner claims leave to file an additional affidavit to bring on record the relevant pages which according to the petitioner could not be filed due to oversight. He prays for 2 weeks' time,
1 week, my lord.
1 week's time. Mr. R for
PWD, my lord.
appears for PWD. Mr. S. Mia for
So one.
higher education. Yes, for higher education. After 1 week. Right. Yes,
My lord, may I please your lordship, my lord? Here the petitioner was appointed in the year 2013, my lord. 2015. And
APSC,
APSC, my lord. Similar order, may-
similar order.
I am come to 141, my lord. Because I am working more than 2 years now, no extension has been given, my lord. So, my lord, my case is squarely covered by this decision.
You fall under direction 1.
One, my lord. Even my case has been given as an example in this judgment, my lord. Ask কিমান no possession? 62, my lord.
Yes, Mr. Government Council.
Lot. Paragraph 60, my lord.
Paragraph 60.
Paragraph 60, page 146.
1.
146, page, paragraph 60.
No, we want the directions.
Yes, my lord, 140.
148.
APSC page 200. This is the direction, my lord. I come under the, my lord, 141, my lord.
English
Appellant-
notice, Mr. Nutt.
Lot,
Heard council.
two 266, page 267, similar orders, my lord. This is the order.
Order, Mr. Nutt.
This is-
This after 4 weeks. Matter be listed on a fixed date after 4 weeks, which is 29th. In the next date fixed, in order. What is the date of the order?
Yes, my lord. Date of the order, my lord. Page 266. August 2000.
No, 21/7/2025.
27/7.
Page 266.
266.
266,
21/7/2025.
21/7/25.
21/7. 2025. Page 266. Shall not be given effect to.
Logic.
Focus in.
Item. My lord, item number 16 is the same, my lord.
604.
Item number 4, my lord.
Hmm?
Item number 4 is the similar, my lord. Impugn order is placed, my lord. It's 2014 batch, my lord.
Where is this order here?
Yes, my lord.
Impugned order?
292.
Page.
Into बदली है no, that's it.
21st of July.
Yes, my lord.
Page.
21, 21.
Same there.
Here also you are under number 2, number 1,
Number 1, my lord.
direction number 1.
Direction number 1, my lord.
List on the same date, huh? 27, I think,
This for
28. Sorry, 20,
Impugn order not to give.
29th October.
29.
I get it, okay, sir. Mass obligation.
Supplementary for motion item 66. This is also same APSC matter, Lordship. We come under 141(1).
That comes in over the.
Number.
It is Bhushan Dawla ko.
Serious. The same matter. The available VC to know.
Look at the Assam Police Service.
APS.
APS. This is item number.
66, Lordship, supplementary.
These are matters where we wanted a VC.
No, not me, Lordship. That is Senior Counsel Owner Chaudhary, Lordship. Earlier matters.
And other.
We can have a VC because these are all similar matters. We can have a VC, but I think you have an unlisted matter. Is it already, is it in court?
File with some.
It has come.
Okay, sir. Okay.
Then we'll have it in the second half.
Lordship, these matters are also similar, but the petitioners herein are from Assam Police Service. They were appointed on 18/10/2016. 2 years of probation is complete. No extension orders are there. The discharge orders, your Lordship will find at page 264.
How many petitioners?
2 petitioners are here, Lordship. Everything is
Discharge
identical.
order is the same.
Yes, identical orders, same date. I've annexed in 264. 265 is the second petitioner's order.
But
Well, our ground is same, but that they fall under 141, Roman 2 and Roman 7. Our ground is same.
issue notice written about 4 weeks. Matters be listed after so and so date till the next date fixed. Entombed order shall not be given effective.
I'm highly obliged. Orders item 5.
Eight to five song. And what are the Bagalar Nama like that? Or any other bench without me.
Item 6 to 8.
In the last occasion, Lordship sought for certain instruction. The learned senior government.
Well, I have communicated to the department. In fact, they have said that the concerned department will be the Social Justice and Empowerment Department. And in fact, the Women and Child Development Department, they have written a letter communicating the matter to the Social Justice and Empowerment. The entire thing has been given to them.
She also wanted to.
Lordship may kindly give us some time. I 1 week time given, because I have communicated the matter to the Women and Child. They now said that it will be with the Social Justice and Empowerment. Although they have a standing council.
Yes, Lordship also wanted to know whether the office memorandum issued by the state government and central government are there still in force or not.
You get these instructions after 1 week.
Lordship,
Yes, ma'am.
kindly keep it next Friday.
NK
Not-
Kolita,
Except
PS for the petitioner. As you are for the review petitioner also.
Yes, ma'am.
Review petitioner as well as for the petitioners. And Mr. D. Nath, additional senior government advocate, submits that further time required for completing his instructions. He prays for a week's time. Matter therefore be listed after 1 week.
He sought for 19, my lord.
If not inconvenient on 19.
Eligibility to matter be listed on 19th,
Yes.
19th.
19th September.
Yeah, please, Allah. Well, this matter we had filed an IA, my lord, for keeping one post vacant. Well, my submission is, my lord, this matter can be disposed of at the admission stage. My lord. It's a long pending matter, 2019 matter. And my lord, therefore, my lord, may I pray, my lord, this matter may come for admission, my lord, and we may be made to dispose it of, my lord. Because it's with regard to, my lord, a person with disability, and my lord, affidavit, the pleadings have been exchanged, my lord. So let the entire matter be taken up in the admission, my lord, then we will dispose of matter.
It is submitted by the learned counsel to the petitioner that although an IA has been filed seeking orders, seeking directions to the respondents to keep one post vacant, it is submitted that since the pleadings are complete, the matter can be taken up. The IA can be taken up together with the writ petition for admission hearing in disposal on another date. Prayer made is not objected to by the respondents. List this matter for admission. On 24th October.
24th October, my lord, of that function.
May it please, your lordship. So there is
Yes.
a contempt petition, non-compliance of the order at 25th of June 2024, your lordship.
Malad, I pray for taking up this matter after some, malad, few days. Malad, we have preferred an appeal. Kindly give us some time, Malad.
All right. Mr. A. Das
Okay,
is for the contempt petitioner, Mr. D. Nath, learned senior learned counsel representing the respondent, submits that a writ appeal has been preferred against the judgment and order dated 25/6.
Yes,
25/6/24.
2024.
Passed in WPC 367 of 2022. He submits that the status of the appeal.
We have preferred an appeal. It is not listed yet. We'll
will
take the
be
steps for
intimated
listing.
before the court on the next day.
Plot
List again after 2 weeks
after 12.
It will be after 15th of October, on a fixed date, your lordship.
on 15th of October.
After 15th of October, your lordship.
All right, then 24th October.
Yes,
Malad.
24th.
let them advise about the
How do you
appeal, your
appeal
lordship.
Respondent 6, sir.
Respondent 6.
Oblige, your lordship.
Malad.
The steps have been taken, my lord, but
Hmm?
the steps have been taken, my lord, but no one has appeared, my lord. We can await, my lord, or
Await service report
Ma'am.
on the sole respondent in terms of the office note dated 14/8/2025. That will be listed again after 4 weeks.
May it please, your lordship. Well, there's some small correction, my lord, page 38, my lord. Page 38, my lord, the second paragraph, my lord. Last 3 line, my lord. The petitioner filed his application for appointment under the die-in harness scheme before the authority in time. However, till date, his case has not been placed before the district level committee, my lord. Well, in fact, my lord, it was placed before the committee, my lord. This is a similar order, your lordship had reviewed the order.
No,
Same order.
therefore, in this matter, it is reflected that his case was not placed before DLC.
My lord. In fact, my lord, it was SLC also passed, my lord.
Only this line.
This month, my lord. Same order, my lord. Same.
So how does it affect the directions.
Nothing, no effect, my lord.
Then if it doesn't affect, why?
Only that much, my lord, because his case was placed before the SLC passed it, my lord, due to want of vacancy, they could not be appointed.
No, ultimately, they are required to take a decision.
Yes,
This is only narration of the fact.
only narration of the fact.
It doesn't have an effect.
Doesn't have an effect, but
Then
because
even
we'll
if we
be,
correct it,
yes, my lord, we'll be in 2 level up, my lord. Because it reflected, my lord, district level committee has not placed before DLC. It was in fact placed before the DLC as well as the SLC also.
what do you say?
Lordship, I have no objection, Lordship.
Now it is to be, as per para 7, it is to be placed before which authority?
Actually, my lord, now that concerned authority, my lord, concerned department, should ask the other department whether any vacancy is
Vacancy
there.
is available or not.
That exercise is to be done by the SLC.
SLC had
Or-
done it. SLC said that
No
they
vacancy.
could not
SLC
be.
sends proposal, Lordship, and the department takes up the matter with the other departments.
Well, I heard counsel for the parties. This is a review petition filed by the petitioner seeking review of the order dated 5/5/25 passed in WPC 2324 of 2023. There are learned counsel for the petitioner submits that while recording the facts in the order, it was wrongly recorded that the case of the petitioner was not placed before the district level committee. Stop. However, factual position is otherwise. The case of the petitioner was recommended by the DLC and was also placed before the SLC. Stop. He therefore submits that since the the ultimate direction in the order is to the concerned authority to take necessary steps to dispose of the petitioner's application for compassionate appointment. The facts narrated in para 2 of the said order will have a bearing while implementing the directions contained in para 7 of the said order. Stop. Therefore, the review petition has been filed for the limited purpose. Para. Ms. U. Sharma, Government Council does not object to the prayer made. Para, considering the submissions made and also on perusal of the petition and the order dated 5/5/25 passed in WPC so and so, it is seen that in para 2 of the said order, it was wrongly recorded that within quotes, till date, case of the petitioner was not placed before the DLC, quotes closed in italics. On the other hand, it is as per the submissions made, as per the pleadings, the case of the petitioner was placed before the DLC and was recommended and also placed before the SLC.
Right.
And what was the finding of the SLC?
SLC, madam, due to want of vacancy, they could not be accommodated.
SLC, due to want of vacancies, rejected the case of the petitioner. Stop. Under such circumstances, in view of the directions contained in para 7 of the order dated 5/5/25, it is now incumbent, it is now the concerned department, namely which department?
Animal and
Animal-
husbandry
animal
department.
and-
Veterinary and veterinary department to examine the case of the petitioner for consideration for appointment on compassionate grounds in respect of any vacancies, if available, in other departments.
Right.
So the the review petition is allowed to that extent. Stop. And allowed to that extent and disposed of. Stop. The order dated 5/5/25 passed in WPC so and so shall be read together with the order passed today in the review petition 227. Disposed.
I'm obliged.
Make notes. Official note dated 2/9/2025 reflected neither AD nor answered notice returned with. Lordship,
AD card has not been received.
no, Lordship. I may be allowed to take fresh step, Lordship.
Office note dated 2/9/25 reflects that AD card is awaited on respondents 3 and 4. Stop. Petitioner seeks liberty to undertake fresh steps. Prayer allowed. List after 4 weeks.
Obliged. Until 16/24.
Lordship, here, Miss M. Bhattacharjee will be appearing in this matter, Lordship. She's on legs in another court. After some time, Lordship, the matter will be taken.
May
Yes.
please your lordship. Lordship, we beg to adjourn the matter today. And earlier it was listed on 2nd of this month. And Honorable Court was pleased to pass an order directing to list the matter after 2 weeks. Now, as per the earlier order, we have been preparing. And Mr. P. Decker, who is leading counsel one of the leading counsel in this case, he is not present today. He is out of station owing to some personal difficulties. So we seek to list the matter on Monday.
Monday.
Yes, Lordship.
Yes.
Lordship, there is some urgency in the matter, Lordship. If it may
Some
be.
prayer made on behalf of the. Where is Mr. Dega?
Mr. Decker went defer for some personal work. And as already the Honorable Court was passed order on 2nd of this month. As part of this order, we have been preparing this case because this is a series of matters.
At 15 then, Mr. Saiwala, you're also appearing. 15th.
Lordship.
Prayer is made on behalf of the opposite party that the arguing counsel, Mr. P. Deka, is out of station and an accommodation is sought for. MSU Sharma, appearing for the applicant, submits that MSM Bhattacharya, additional senior government advocate, is pleading the arguments on behalf of the government. Considering the difficulty expressed by the respondent, matter stands deferred to be listed on 15th. Considering the difficulty expressed by the applicant and the urgency expressed by the opposite party and urgency expressed by the applicants, matter stands deferred to be listed on 15th. Mr. Dr. for?
Number 1.
And you are for?
I'm in 4 cases, man.
Oh, okay. Learned Mr. A.K. Dotto and P.S. Bhattacharya appears for the respondent Union of India.
Interim order is there, Lordship. That may be extended.
Whatever is there, it'll continue till 15th.
Lordship, obliged, Lordship.
25.
Your lordship.
Yes.
But my prayer is for listing of the matter for hearing after vacation.
Oh, there is an IA here for something?
That
The impugn order that was passed against me, that was put on embargo because, Lordship.
You want the matter to be listed for hearing?
Yes, ma'am.
Mr. C. Chaudhary, learned senior counsel, assisted by Mr.
Hidayat Sharma.
Hriday Sharma. Submits that the matter be listed for the hearing in the month of October. 30 October? 30 October
30, Lordship.
30.
Public.
May his lordship kindly pass over for time being. MP Sharma is under court.
In this matter, my lord, I'll request some time to get instructions. Because my lord, here, my lord, they are praying for early conclusion of the departmental proceeding, my lord, initiated against the petition. They say because my lord, now some of his colleagues have been promoted, so my lord, his promotion should also be considered. And one more prayer, my lord, they want is that, my lord,
Let him come. Let him
my
come.
lord,
Time being.
May it please, your lordship. I appear for the respondents here, my lord. Today is my first appearance. My lord. I'm praying for some time.
As per office note dated 23/7/25.
Maybe granted 4 weeks time to find a response.
Service on respondent 1 to 5. Stands complete. However, you are appearing for
For all the respondents.
1 to 5.
1 to 5.
Mr. B. Sharma appears for 1 to 5. He prays for 4 weeks time to complete the instructions. Mr.
Yes, Ahmed, on behalf of PK Rathod.
S. Ahmed on behalf of Mr. P.K. Roy Chaudhary appears for the petitioner. Any objection to the prayer made?
Sir is lagging in another court.
I'm asking you, not your sir. List after 4 weeks.
The incident petition, my lord, for including opposite party number 5 with respondent number 5, my lord.
IA for
I for imprisonment, my lord.
implement
Yes, my lord.
of
Okay, party number 5, my lord.
respondent number 5.
Yes, my lord.
Who is respondent 5?
The biological daughter of Alurani Day, my lord. So there are some statement regarding my lord.
Heard learned counsel for party.
Lordship, I have an objection. How
You're
can that
issuing
be,
notice.
Lordship?
We are issuing notice.
Lordship.
Issue notice. Return number 4 weeks. Mr. B. Chakravarti appears for all the respondents. 1, 2, 3, 4.
1, 2, 3, 4.
Steps on as such notices are waived. Extra copies be furnished within the period of 1 week from today. Steps on respondent 5 by registered post ID as well as usual course within 1 week from today. List after returnable date.
This particular matter also does not come under the recent executive order because once he died in 2014 and the DLC recommended, but SLC could not recommend, Lordship, in its minutes of meeting of 2017. And the matter to fall under the new executive order, Lordship, it does not fall under any other condition of other death. So, Lordship, I may be allowed to take some instruction from the SLC, Lordship, that because this is a meeting of 2017. After that, it might have.
My lord, on last occasion, I was directed to apprise before this onward regarding the batch of writ petitions. During pendency of the writ petition, the government had issued a office memorandum which was put to challenge before this honorable court. And this honorable court was pleased to dispose of all the matters, directing the authorities to consider all the cases now. And
That was fine, Lordship. Had they been challenging the OM, then would have fall under the new executive order. But in that prior lordship, they had neither challenged the OM or this matter particularly comes under the order of the single judge. So that is the only thing, lordship. Had they challenged the OM, it would have directly fall under the point number 1 of executive order.
What is that executive order?
Executive order, lordship, they are sending it. The soft copy I have.
You send it to the court master.
Yes,
Take
lordship.
it up. We'll call it up after a while.
Last one, lordship.
Executive order from the
Recently, they opened a piece. Please suppose.
The executive order.
Will kindly say the last order, my lord, 28. Matter relates to, my lord, the non-payment of arrears salary, my lord.
Yes.
But the counsel for the AG, my lord.
And name was not reflected. He has not served me a copy. Lordship, will let him serve a copy like next Monday. Next
We
Wednesday.
recorded
Lordship.
your name. Last order, request made
Lordship.
by you.
In the causality, this is not reflected.
But may not
It
be
may not be
reflected.
so. And the copy has not been furnished to me. Next Wednesday, Lordship.
You furnish a copy.
My lord,
In deference to the earlier order dated 2008-25, the Standing Council Accountant General, Mr. B. Chakraborty, was to furnish instructions today before the court. So, Mr. Chakraborty and Mr. Chakraborty today submits that copy of the writ petition was not furnished.
Because we are not a party yet, Lordship.
Was not furnished to the Standing Council, and therefore instructions could not be obtained, as the Accountant General is not arrayed as a party respondent in the present proceedings. So, considering the prayer made by Mr. B. Chakraborty, we deem it appropriate to defer the matter to be listed on 24th of September.
my lord.
24th
Lordship.
or 25th of September.
My lord.
And our name may be reflected in the cause.
And extra copy be furnished during the course of the day
My
to enable Mr. Chakraborty to complete his instruction. We are fixing it. Don't burden the registry. Note down the date, 25th of September.
highly hope.
List accordingly.
May I pay your lordship? Over here, lordship, I want to file an affidavit, lordship, therefore I pay for some time, 2 weeks time, lordship. To bring certain documents.
Mr. A. Deka,
doctorate.
counsel for the petitioner, prays for further prays for time to file his additional affidavit.
Oh, affidavit, lordship.
An affidavit to bring on record certain documents which he submits would be relevant for a decision in the case. Mr. S. Dr. Senior Counsel, assisted by MS K. Bora.
All
There
right.
is not object to the prayer made. No objection. Matter therefore stands referred to be listed after 2 weeks.
Lord.
Obliged.
Obliged.
Your
For
lordship,
non-payment of the retirement benefit, my lord, to the petitioner. And till date, my lord, they have taken several times, till date, they have not filed the affidavit also.
Yes.
your lordship, my senior is in legs in court too.
Who is your
Could you
senior?
pass over the matter for the
Who is your
time?
senior?
MD Bora, Standing Council Transport.
We'll pass it over. Let her come.
Matter.
33.
Yeah, please, Lord. Already in this case, my lord, this honorable court, after perusing all this affidavit of the government, with regard to Upenda's case, my lord, that order has been passed by this honorable court. Only, my lord, in time, my lord, this petitioner could not approach for contempt. That is why this writ petition has been filed again, my lord. So, my lord, lordship will find the honorable court's order, my lord,
Lordship may direct the respondent's authority to comply with the honorable court's order, my lord.
What?
At page 30 starts, my lord. 35, my lord.
তো এটা আমি এফিডেভিট ফাইল করছিলাম
নাই এই মেইন কেসত আগতে
মানে
খালি
এইটো ডেটো 6412 কৰা নাই ন আমি
6414
6412
6412 কৰা নাই সেইটো কৰাব দৰকাৰো নাই না অলৰেডি গভৰ্ণমেণ্টে আগতে এফিডেভিট ফাইল কৰি মেলি গোটেইখিনি কোৰ্টে অৰ্ডাৰ পাছ কৰিছে They have admitted rather, my lord. Para 5, my lord. Of the order, my lord. At page 37, my lord. On consideration of the submission made by the learned counsel for both sides, then the court takes notice of the statement made by the respondent number 3 in paragraph 7 of their additional affidavit in opposition filed on 2/2/2021, which is to be following effect.
Once an order is passed, why do you want
Yes.
another order?
No, my lord, since this writ petition was filed in
You slept
2020.
over it. You have got an order.
That's true.
You did not pursue it if you wanted to thereafter.
My lord, this lastly, lordship will see the application 8/3/21, my lord. Page 40. Then, my lord, now, since 2021, nothing was came out, and my lord, within the year, the contempt had to be filed, my lord, and the petitioner was awaiting for the result that it will comply to it. Nothing has come out. So, my lord, after about 3 years had gone by, then writ petition has been filed. Lordship may dispose of the matter on
No,
the
no,
basis.
no, we are not passing orders like that. Once an order is passed, you want another order.
No, no,
After another 2 years, you'll come and say, no, that order earlier council could not comply with.
only I am praying, my lord,
Ah.
on the basis of the court's order, lordship may dispose of.
Court's
Only one line, my lord.
Court's order is already.
Otherwise, my lord, I cannot file the contempt, my lord. That is
We
the.
don't know, you examine the provisions of contempt and address the court.
No, my lord.
We are not here to pass orders after orders after.
No, no, I'm not praying, my lord. I have also gone.
You have to explain why this order was not, have you explained anywhere why this delay has happened?
My lord, this I have.
Why you choose not to invoke the contempt jurisdiction? Any explanation?
Yes, my lord. Yes, my lord. Para 13, my lord. Para 13, that the petitioner under legitimate expression that his case will be considered by the authority concerned in view of the honorable court's order dated so and so passed in WPC number so and so. As a result, contempt case could not be filed at the relevant time. However, now the time limit has been elapsed. As a result, this writ petition is filed for appropriate relief and order so that the poor petitioner gets the justice in terms of the honorable court's order as mentioned above. The respondents cannot be escaped from its liability so and so, which is in force till date, since no appeal review has been filed. And in earlier occasion, I have filed the writ petition and it was withdrawn. I've been told that the finance department is necessary party, so I have filed this again writ petition to include the finance department also. My lord, only, my lord, in such cases, I have found, my lord, I have also filed some of the cases where honorable court directed that since earlier order has been passed, meaning thereby it was directed to comply with the earlier court's order dated so and so, and that will work, my lord, for me. And I can file the contempt, my lord.
You are
Yes,
asking
just-
the court to.
I'm sorry, my lord.
You are asking the court to pass, to act as if it is performing some clerical work.
No, my lord.
There is an order passed. You have to explain why you have not pursued this order.
I have
Why,
pursued.
why have you slept over
I
the
have
order?
pursued. This, my lord, I have pursued page 40, my lord. This application was submitted, my lord.
Yes.
Lordship, I humbly submit before the call is that although this matter pertaining to the finance department is required to answer, but thing is that Lordship, there is already an order where he is the petitioner. At para number 8, that concerned authority shall do the needful so as to extend the benefit of minimum
That is
scale of
what we
pay.
are asking you. Why has it not been done?
The thing is that if he is not satisfied, if he feels like that this is not been complied, you go and file and contempt, then again you file.
That's for us to decide. We are asking you why this order has not been complied with.
No, today I doesn't know whether it has
So you
been.
get your instructions. Tell us why this order has not been
Yes, I will
complied
get the
with.
instruction, Lordship, in that.
Which department is it?
It is Lordship, Social Welfare Department is here, Lordship.
Now it has been changed. It has been,
Which department?
it has been,
Director of Social.
Women and Child Development.
That time it was Director of Social Welfare.
All right, whatever it was there. Who is for women and child development? Is there? You are there. Get your instructions.
get that,
Why
sir.
this has not been complied with. This after 4 weeks, Mr. CKS Borua, government advocate, will obtain instructions from the Department of Social Welfare, now re-nomenclatured as Department of Women and
Child Development.
Child Development, as to why the directions contained in the order dated so-and-so, passed in WPC so-and-so, which was earlier filed with the writ petitioner, was not complied with, in spite of the same being brought to the notice of the concerned authorities. Let these instructions be placed before the court on the next date fixed.
Master orders.
You have the extra copies, etc., available with you? Please furnish one extra copy
One extra copy I required, Lordship.
today. Extra copies of the writ petition be furnished to Mr. Borua within the course of the day by the council for the petition.
Obliged, Lordship.
34. Lordship, they had not filed affidavit. We have to check.
My lord, we have received instructions, my lord. From the government, we will file it in a week.
What is your prayer here?
My case has not been considered for promotion, Your Lordship. I am in
For-
zone
for?
of consideration.
For
For the post of senior assistant, Your Lordship. I'm serving as a junior
Promotion.
assistant.
promotion.
Promotion, Your Lordship. I'm in the zone of consideration. My case has not been considered, Your Lordship.
Any instructions, Mr. Dor?
My lord, I have received Parabay's comments, my lord.
Oh. Are you filing an affidavit?
Yes, my lord, we'll file. In 10 days, we'll file, my lord.
How much time?
10 days. my lord.
Mr. T. Deori for the petitioner, Mr. R. Dor for which department? PWD.
PWD, my lord, 1 to 5.
PWD. Who submits that instructions have been received. Learned counsel prays for 10 days time to file his affidavit. Prayer made is not objected to. List after 2 weeks.
Very grateful, Your Lordship.
Pensionary matter pertains to pensionary benefit. Your Lordship had issued notice on 2/4/2025, my lord. The affidavit would be required.
Which department is it?
My lord, finance is involved, my lord. And AG is also there. But I think primary department will be finance, my lord.
Who's for finance? Finance department? Finance department? Heard Mr. A.K. Borua, counsel for the petitioner. The petitioner is before the court praying for release of pensionary benefits, including GPF and leave encashment dues. Notice was issued on 2/4/25. And a notice was accepted by Mr. P. Nayak, additional AG for Assam, for the finance department. Today when the matter is called up, none represents the finance department. No affidavit has been filed. We request the government advocate present in court, MS U. Sharma, to obtain the required instructions from the finance department and file necessary affidavit if so advised. In the
Lordship,
meantime,
I'm appearing for respondents 5 and 6. Lordship, pension department.
We are asking you to appear for finance also. You are a government advocate. We had directed you to appear.
Lordship,
Matter be listed on 27th of October.
Oblige. Leave, leave.
So this particular 36, Lordship may need to see go through the new executive order. So I have already sent it an email. Because Lordship, this is a matter of compassionate appointment.
All right, let us understand what is the executive order.
Yes,
Lordship, once, coordinate basis with
it's a new order. No?
here I am challenging the office memorandum also, 18/9/2020.
No, সেইটো নহয় তাক it's an executive order. না, সেইটো আছে তুমি 15 নাই
15/9/2025 আগত জমা দিব দিছে মই ঠিক পাবো
জমা দিব দিছে তাৰপিছত তুমি লিখিছা নাই This Lordship seeing the executive order, Lordship, 30 August. Lordship may kindly see point number 2. Cases where rejection of application for compassionate appointment has not been set aside by any court of cases, wherein such rejection order has not been put to challenge prior to 4/4/2025, shall not be reopened unless there is a specific direction from the court. But Lordship, this particular writ petition has been filed in the month of June of 2025. So post 4/4/2025. And they have also challenged the same OAM and everything. So that
Lordship,
is
my matter is now pending before the SLC Lordship. Lordship, in this regard,
That is the-
Lordship, coordinate basis to dispose.
Why are you giving one order after the other? How many orders do you have?
Lordship, no, they,
Who has passed this order? Who has given this order?
Lordship, WPC 2/8/25.
2/888.
Full Kalam Azad. This matter was also filed, Lordship, after 3/4/2025. Lordship. Lordship, last paragraph, page number 2, Lordship.
Are you aware of this 38 notification,
he is not a
executive order?
Lordship, notice was published in Lordship, in the newspaper, Lordship, were requested to submit on or before Lordship 15/9/2025, Lordship, challenging any high court order, Lordship, challenging the office memorandum, Lordship.
That is point number 1 he is talking about. His case does not come under point number 1.
What are the facts of your case?
Lordship, my proposal is duly, Lordship, recommended by the DLC, Lordship,
When?
on 17/8/2026, Lordship,
2023?
23, Lordship.
Then?
Therefore, my matter proposal was forwarded to SLC, Lordship. But Lordship, in the 18/9/2024, Lordship, one office memorandum was issued, Lordship, whereby decided to not to place any matter before the SLC or DLC, Lordship. Therefore, I am challenging this, Lordship, OM, Lordship.
How is it covered under point number 2?
My matter is still pending before the SLC, Lordship.
It is covered under point number 2, Lordship, because by rejection of application.
It's not rejected.
Already recommended by the DLC, Lordship.
Recommended by the DLC, placed before the SLC. How is it covered by point number 2?
My case is already recommended by the DLC, Lordship. Only Lordship, my limited power to give direction to place my matter before the exchange.
Oh,
Have you seen this executive order? Do you have a copy?
Lordship, I have only the notice, Lordship, which was published in newspaper.
No, you give him a copy. You give him a copy, both of you study and come back.
Lordship, on the 3/9/2025, Lordship, and Mondol.
Have you read this executive order?
Yes, Lordship, after publication of executive order also, coordinate bench also.
I am asking you a question, you are giving me some reply. I am asking you, have you read the executive order 38/2025? Yes
No,
or
Lordship.
no?
No, Lordship.
No.
Lordship, make,
Read it and then come back.
Lordship, one more thing, Lordship, make only see Roman 2 of the.
No, both of you read it together and come back. None of you have read it and you are trying to
No,
apprise the
this
court.
Lordship, where the reject.
You read it properly and then come back. We are giving you time. Don't compel us to pass any
Lordship.
any other order.
Otherwise, compensation here.
Read it. When you are appearing before the court, read whatever documents are relevant. There are a photocopy for you. Photocopy for you. List this matter on after next week, 15th.
Lordship, last date was on 15 line, Lordship, as per notice, Lordship.
Then we'll take it up at 2 p.m.
Yes.
You come, read and come.
Lordship. 38 also similar also.
All right, 38 also.
I think 39.
Yes.
My lord, what had happened in this case, based on an inquiry conducted by the Deputy Commissioner, a proceeding was initiated and the petitioner was dismissed from service. Apparently, there was violation of Rule 9 of the rules. Therefore, this honorable court by judgment at page 47, my lord, a relevant portion is at page 55 and 56.
Yes.
I think, my lord, my learned friend wants to say something.
Mr. Raj, I am praying for an adjournment today, my lord. Any other day.
Anyway, so what happened?
My lord, what had happened? This or the direction of the coordinate bench is issue an explanation. Then I will reply. Based on the reply, if you are satisfied, then you may proceed departmentally.
No, they have not
They
complied.
have not followed their procedure mandated in this order. Now they have done the same thing which they did earlier and which was interfered by this honorable court.
Then
Because
they did-
supposing they record their satisfaction, then if it is made known to me, then I can put a challenge to it that the opportunity has been denied to me.
and then it was issued, you again challenge.
I challenge.
And then
It
it
was
was
also interfered with. Now third time they are going to do the same thing.
Yes, Mr. Bodhagur.
My lord, can it be fixed next Monday, my lord, 15?
Next one, let it be Wednesday. my lord.
Wednesday.
Wednesday. Yeah.
17th.
17.
All right, as agreed, let's this matter and the prayer of Mr. I.K. A. Bodhagur. I Bodhagur. Matter stands deferred. As agreed to by both council, list on 17th.
Well, let it be 18th, my lord.
18th September. 18th September.
Yes. Only interim order will continue.
Interim order passed early will continue.
Timing, I think 26.
Yes.
Lordship, the repetition, we have challenged the departmental proceeding, Lordship. Whereas in the IA, Lordship, we have sought for our promotion, Lordship.
We sought for?
Promotion, Lordship. Since Lordship may kindly turn to page 30, Lordship. This is the promotion order.
We need to notice in the IA.
Lordship, that may be done. Lordship, why the DP was initiated against me?
Are you pressing your IA or not?
Yes, Lordship.
So we'll issue notice if you want to press the IA, or if you want both matters to be taken up, we'll fix for admission.
Lordship, in the meantime, my friend may obtain instruction with regard to this, Lordship. I
Right.
know Lordship will issue the notice. I am agreeable to that, Lordship, but then
Third counsel for parties, the IA, issue notice returnable 4 weeks. Mr. Odhikari appears on behalf of all
yes, my lord.
the respondents, therefore notices are waived. However, extra copies be furnished within a period of 2 working days. The respondents may complete their instructions and file objections if so advised in the IA. List again after 4 weeks.
Lordship.
After
The
4
date may kindly be fixed, Lordship.
29th of October.
I'm obliged, Lordship.
Timing, I think, 29.
None appears. The matter is called up second for this next week.
Item 32.
I'm sorry, my lord, I was on legs, my lord. My lord may dispose of this matter. Already
In the
submitted.
absence of the counsel for petitioner, we adjourned it because you were not available. MSMD Bora for respondent. You are also appearing.
ASCC? That lordship is already disposed of.
No, sorry. Which matter are you appearing?
32.
32.
32.
This is
Okay.
retirement.
Yes. What has happened here?
Well, Lordship has just few days ago disposed of a batch of petitions concerning the same thing.
Retirement benefit.
Well, this was covered by that judgment only, and this is the
You
present.
give him a copy.
Yes.
Share with him a copy.
Well, this is the present dues, my lord.
Judgment of yes. Copy is.
Yes. Yes, sir. At a batch of petitions, the total dispose of course within 6 months of the payment.
Yes.
Yes, madam, that can be.
We close it.
Yes,
All right. Heard counsel for parties.
Malada, I am for the legal aid counsel.
Mr. R. Islam appears for the legal aid counsel as a legal aid counsel.
Yes.
MSMD Bora for transport, Mr. R. Somoa for ASTC. Disposed.
Much.
It will multi-button.
Item 40.
Lordship, kindly pass off the matter and fix it at 2 p.m. My senior is on legs in another court. My senior is on legs in another court. Kindly fix the matter at 2 p.m.
2 p.m. already.
Lordship heard this matter extensively on the last day, though I forgot what I argued on that day.
Overstay.
Overstay, Lordship.
Yes, ma'am.
Lordship, ultimately he placed 2 judgments and Lordship directed me to go through those judgments. Lordship, 1 judgment I found, Lordship, 2nd judgment I have yet to find out, Lordship.
Which judgment?
Lordship, 2 judgments he furnished, Lordship. One is WPC number 8048/2017. That is 1 judgment, Lordship.
Okay. Judgments of this court.
No, yes, Lordship.
One malad.
One from this judgment I have, Lordship. On the data. It is a copy of the
Well, it only request made by.
2021 5 GLT 61 fully cover.
On the request made by the council for the finance department. PWD list again on 18th. 18th.
Lordship.
Of September. An attempt will be made to dispose of on the next date.
May I please, Your Honor? Your Honor, may kindly take this matter up to Puja vacation now.
Prayer for adjournment is sought for by the council for the petitioner, list again after 4 weeks. MSA Gayan appears for the respondents. 4 weeks.
Lordship, here in this matter, we have received the records, Lordship.
Yeah.
So, Lordship, can this be taken after some time? Additional AG will appear in this matter.
2 p.m.
2 p.m. Lordship. Oblige, Lordship.
This matter pertains to promotion to the post of junior assistants from the post of grade 4 mallet. What had happened in this case, mallet, the petitioner was initially appointed by order dated 29 to 1992. And thereafter, his name was,
My lord is taking up for disposal, my lord, this matter.
Pick up.
My lord, I'm ready, my lord.
Meetings are complete.
Everything is complete, my lord.
Yes.
You are appointed as a.
As in Chokidar, my lord.
Huh?
Chokidar.
Chokidar, grade
Page,
4,
page 34, grade 4.
regularized.
Subsequently, my lord, regularized by the order dated page 38, my lord, 9/11/2005. Then his name has been forwarded for promotion under the 10% quota.
Under what rules? What rules?
The rules I have relied, my lord. The Assam Ministerial Staff District Establishment Public Works Road Department Office Service Rule 2021. And the relevant rules, my lord, is at page 59. 90%, well, page 59, serial 3, 90% of the vacancies occurring in a year shall be filled up by direct recruitment in accordance with the procedure in Rule 7. The direct recruitment shall be made through so and so. Then B, my lord, 10% of the vacancies in the cadre of junior assistant in the respective establishment of the divisional office circles in a year shall be filled up by promotion subject to availability of the suitable candidates, provided that any shortfall of this reservation due to non-availability of the adequate number of suitable candidates in a particular year shall not be carried forward to the.
You satisfy all this under C?
Yes.
Eligibility?
Yes, my lord. Eligibility.
You satisfy?
Yes.
Okay. Then?
And then, my lord, what happened? Initially, his name was forwarded, and at that point of time, his case was rejected on the ground that he was, at that point of time, he was not acquired the graduation, my lord. Because subsequently, rule has been amended. Earlier is high secondary, then subsequently, after obtaining the qualification, his name again has been forwarded. And finally, my lord, these Honorable Court has also given a direction due to non-disposal of his case, my lord. And on the basis of the direction, the impugned order is at page 70, my lord. Now, that has been rejected on the ground that he is holding the personal post. And after this challenge, my lord, the PW department
Where
has,
is your appointment order?
well, appointment order is at page 34. In the interest of public service, the following person are hereby appointed in the newly constructed machine board, Lolita, with effect from 1/1/1992 in the scale of pay mentioned against each post. The arrangement is purely temporary and may be terminated at any time without assigning any reason thereof. And his name is serial number 3, my lord. Vidyadhar Sinte. This is the scale of pay. And then, my lord, his service has been regularized. Kindly turn page 38, my lord. In pursuance of the Undersecretary to the Government of Assam, PWD Audit Branch, Dispur, Guwahati 6, by letter dated so and so, and the Executive Engineer PWD Jorhat State Road Division, by office order dated, the following WC staffs are hereby brought to regular cadre with effect from 22/7/2005, subject to fulfillment of the following conditions. My lord. And his name as reflected at serial number 4, my lord, Vidyadhar Sinte. Then, my lord, a seniority list has also been published, which is at page 41. And the name of the petitioner reflected as page 42, serial number 34. And thereafter, his name was forwarded for the post of, for the promotion to the post of junior assistant. My lord.
Where have you been regularized?
But regular is at page 38. Order dated 9/11/2005. Initially, his case rejected on the ground that he did not have the requisite qualification. And
Where is that order?
initial rejection letter is at page 47, my lord. With reference to the subject cited above, I am directed to inform you that as per the Assam Ministerial District Establishment Amendment Rule 2015, issued by notification dated 15/10/2015 from General Administration B Department for so and so to promotion or recruitment to the post of junior assistant, the requisite qualification is bachelor degree in any discipline from recognized university or any examination declared equivalent thereto. In view of the above, the petition submitted by you for promotion to the post of junior assistant could not be considered as you have not fulfilled the requisite qualification as required by notification mentioned above. In this regard, the GOV's earlier communication by letter dated so and so is also enclosed here as stated above. Then after obtaining the qualification, we'll just come to page 51. Malad. His case again has been forwarded on 19/1/2021. Herein, my lord,
You're seeking promotion to which post?
To the junior assistant.
And what is there in page number 51?
Yes, 51 is the finally forwarded his name after acquiring the requisite qualification.
But this is for upgradation. Your name was forwarded for upgradation.
With reference to the subject, I have the honor to forward here with Sri so-and-so, Vesugida so-and-so, regular MR labor regarding upgradation from grade 4 to junior assistant, but written as upgradation, well, actually for promotion, as per the that rules, well, Assam Ministerial Administrative rules.
Then?
And then, well, his seniority position has also been mentioned here at page 53. And then, my lord, while his case was not considered, then petitioner approached before this honorable court, and this honorable court, by order dated 28/3/2022, at page 68, dispose of the same with a direction to consider the letter dated 19/1/2021. And accordingly, the final order has been, impugned order has been passed on 4/4/2022, which is at page 71. Now they have taken this stand that with reference to the subject cited above, I am directed to inform you that as per observation of personnel department communicated by endorsement letter dated 26/7/2021, person incumbents holding the personnel post or ex-cadre post are not entitled for promotion to the cadre post where service conditions are governed by the service rules. As the incumbent is holding the personnel post and as the service condition of grade 3 employees are governed by service rules, hence as per observation of personnel department, the promotion to the cadre post of junior assistant in respect of the so-and-so cannot be entertained. This is for favor your information and net poll. And after this challenge, my lord, the PW department has filed an affidavit in opposition, my lord. And in their affidavit in opposition, my lord, kindly come to page 87, my lord. They have annexed this and their stand is that pursuant to these letter, my lord, my service has been regularized. And these are all for MR worker, for master role worker. And here in this state is clearly stated that these posts are personal posts. Is at page 87, my lord, and running page.
Yes.
And then, my lord, I have filed the reply. If, my lord, I am holding the personal post, then, my lord, pay fixation has also been made. Page 102. This is the pay fixation.
What has personal post and pay fixation got to do with it?
My lord,
These are basic.
only the basic payment has been made to the master role workers who have provincialist, my lord.
Provincialist?
It's regularized, my lord.
Personal pay and pay fixation, are they connected? No.
My lord, let me explain, my lord.
Ah.
My friend is little confused
Ah.
regarding, my lord, what is personal post and how it is to be dealt with.
Ah.
My lord will come to page number 38 of the writ petition, my lord. His regularization order, my lord.
Yes.
My lord will find here, there is a reference to a letter dated 39/2005. The executive engineer is referring to this in persons to the Undersecretary's Government of Assam PWD Audit Branch by letter such and such 39/2005.
Okay.
My lord, just I'm holding here for a moment, my lord. This 39/2005. Now, my lord will come to page number 87, that running page that my friend was referring to, our affidavit.
That is the letter.
That is the letter, my lord. So, my lord, this letter, this is the letter by this letter strength only. Everybody around 8,500 people got regularized, my lord. 8,598 numbers of master worker were regularized. We were very categorical, my lord, that these posts will remain personnel, no promotion. With, my lord, demise or retirement, this will get abolished. Now, coming back to that, such matter was challenged before this court and it went up the division bench.
What is the Dilip?
Division bench had held, my lord. I have annexed.
What is the name of that?
Dilip Talukdar, my lord.
Dilip Talukdar.
My lord, I have annexed that in my affidavit, my lord.
Now, Dilip Talukdar is further not challenged.
No, my lord, not in Supreme Court, my lord.
But some matter connecting to that is pending before the apex court.
That is Upendas.
Upendas.
Upendas is, my lord, regarding regularization. This is regarding whether a regularized MR will get the next promotion, my lord. Here, division bench is clarified, my lord, in the last page of my affidavit, my lord.
But, my lord, one thing, my lord, kindly see the nature of appointment. And others MR workers, they have appointed as fixed pay.
We are not on that. We are on the judgment of a division bench of this court where it has clearly held that personal posts you are not eligible for promotion. The right or wrong, it's binding on us. And if you're holding a personal post, then you're covered by the judgment.
Yes, my lord. In that case, my lord, but my humble submission, my lord, is merely his name and inclusion of his name with the other MR workers, my lord. So
You read the judgment and argue and tell us that the judgment does not cover the facts of the case. You refer to the judgment and tell us that the division bench judgment is not applicable here. We'll hear you, otherwise it is applicable.
then, my lord, can you take up, my lord, any other day, my lord?
My lord, these remain part heard only on this ground for almost 1 year. Every other day, my lord friend was taking a time, my lord.
No,
My lord,
please don't mislead this court, my lord.
My lord,
But in that I have an objection, my lord.
We will.
My lord, can you
My lord
see
will
the,
keep it part
can you
heard,
see
my
the
lord.
order set?
Matter be heard.
How many times I have taken time, my lord?
My lord will
heard in part.
Please don't submit like that, my lord.
My lord will keep it part heard, my lord.
Please don't submit like that. Please, my lord, can you see our order set? How many times I have taken time?
It is there.
Why you are blaming me?
When do you want it?
But any date, my lord, after vacation.
After vacation.
My lord, before
Or, my
vacation.
lord, before vacation, my lord.
Before vacation. 23rd.
My lord.
Yes.
23rd September. For further hearing.
Obvious.
Mr. R. Islam for petitioner, Mr. R. for PWD.
I'm sorry, my lord. Item number 29. This matter was listed by order, my lord. I was present, my lord.
We passed some order, no?
My lord, because my lord, Monday is the last date. There is an advertisement issued by the authority to submit the particulars by Monday.
What order have we passed? Next week. Monday is the last day for what?
For submission of documents. Thereafter, they will not consider any.
For what matter? For what documents? What matter?
Compassionate appointment lawsuit, there this thing, SLC recommends some of this challenge. SLC was being challenged here.
Already you call it up at 2 p.m.
No, it took Purana case, 2023.
Yes, 2 p.m.
Wait, Your Lordship, in this case, Your Lordship, a departmental proceeding was initiated against me, and thereafter I was removed from service. Your Lordship may kindly peruse for a moment the counter affidavit the edition filed by the respondent number 234. Your Lordship, page 46 is the complaint. It was filed against me, Your Lordship. Page 46, may I read, Your Lordship? Of the additional, of the affidavit in opposition, the counter affidavit filed by the respondent authorities, Your Lordship. This was not provided to me during the course of inquiry, Your Lordship. That is why I'm reading it from page 46. May I read, Your Lordship? With reference to the subject cited above, may I inform you that I have been given the duty of looking after attendance of the employees of ASIDC Limited, including up with the help of a biometric attendance machine that has been installed in the head office. I have been keeping records of the attendance obtained from the biometric attendance machine in my office computer on a regular basis. But on 22nd November 2022, when I had extracted the attendance from biometric attendance machine into my computer, I found the attendance of all the employees have been marked as absent for the 2nd of November 2022, when through the employees had attended office. In this regard, may I further inform you that Sri Debojit Soikia, sub-engineer concerned in TS division near Drunken State, had fiddled with the biometric attendance machine on the evening around 5 p.m. on 2nd November 2022, when the employees had come to give their attendance, he had delivered a few blows on the machine, and in spite of my request him to move aside so that the other employees could give their attendance within the stipulated time, he has quite rude and abusive in his manner and language. A video of the scene captured with my mobile is present as evidence of the scene that Sri Debojit Soikia had created. And this was the case, Your Lordship. Thereafter, Your Lordship may kindly peruse page 28 of my writ petition.
Yes.
The so-called no, page 28, 3/11/2022, so-called notice and suspension letter. It has been reported to the undersigned by Sri Priya Kumar Sinha, Junior Assistant cum Computer Operator, PA to MD, who has been allotted the duties of keeping attendance of the employees of ASIDC up through biometric attendance machine that on 2nd November 2022, at around 5 p.m. you were found in a drunken state and fiddled with the biometric attendance machine when the employees came to their attendance. It is also alleged that you had delivered a few blows of the machine in spite of requesting by Sri Singh. Also, you have shown abusive language to him. It is gross violation of office discipline, decorum, and misconduct. In view of the gravity of the alleged misconduct, you are hereby placed under suspension with immediate effect. Your reply should reach to the other 5th of November 2022 as to why disciplinary action should not be taken against you. Now, Your Lordship, thereafter, page 30. I have filed, sorry, page 29, Your Lordship, I filed my reply. Your Lordship may kindly peruse my reply.
You did not file the appeal.
No, Your Lordship, I'm not filing appeal because in this case, Your Lordship, no charge sheet was provided to me, no statement of allegations were provided to me. The inquiry was conducted in a very perfect manner.
By which department?
This is Assam Small Industries Development Corporation Limited.
Who's appearing here?
Lordship, there is a standing counsel who had appeared on the last occasion, A.S. Chaudhary.
Where is the standing counsel?
A.S. Chaudhary will be it.
Is the name reflected here?
Yes, in the order dated 19/3/2025, Lordship. Departmental.
This is item number
45, Your Lordship.
45.
The name of the council has not been reflected, Your Lordship.
Into standing counsel will assess.
Naam to
Naam to department.
Is he available in court by any chance?
A.S. Chaudhary. Any number.
Where is the inquiry report is here, not here?
The inquiry report, Your Lordship, is at page
All right, you
47.
give A.S. Chaudhary.
Yes.
Let us wait and see if he is available. Standing counsel ASIDC. After some time.
47.
47.
Lordship, in this matter, the pleadings are complete, Lordship. Lordship, kindly fix the matter at matter hearing, Lordship, after the petition, Lordship.
Yes, Lordship, affidavit is filed here, Lordship.
The heard counsel for parties, it is submitted that the pleadings in the matters are complete. Accordingly, issue rule. Call for the records, matter be listed for hearing. Month of November. Yes.
Okay.
Yes.
This is regarding deprivation of right of consideration for promotion, my lord. Lordship may kindly see the selection list, my lord, the seniority list of grade officer. It is regarding promotion from grade E to grade D. Your Lordship will find it at page 25.
25.
My name appears in serial number 5. Sri Pranab Kumar Das, SC candidate. Then Your Lordship will find the
Pleadings are complete here?
Yes, Lordship. Pleadings complete, Lordship. It may be fixed for hearing, Lordship.
You are claiming for promotion.
Yes, my lord.
My right of consideration of promotion that was rejected, my lord. I was not promoted. The others were promoted. And your lordship will find the order for promotion and
Why was it rejected?
my lord, one allegation,
Departmental
my
proceeding
so-called
is-
notice was issued in respect of me, my lord, regarding a home loan. I took a home loan at the land which was mortgaged first, my lord, that mortgage, land was disputed, and that is why another land was approved by the authority, and in accordance with their approval, I constructed the house. And according to them, it was suppression on my part. That is why the so-called notice was issued. And that is the cause behind for non-consideration of my promotion.
What happened to the inquiry?
No inquiry was held, my lord, no charge sheet was issued. No inquiry was pending.
Charge sheet issued.
No inquiry was pending while the right of consideration of promotion that was approved, my lord. Nothing else, my lord. I have stated in my petition. The orders were made, my lord, 5/7/2021, and now after that, my lord, into 2022, I think, my lord, the so-called notice charge sheet was issued, my lord.
Yes,
So
charge sheet
during consideration of promotion, my lord, there was no pending inquiry, my lord. There is
Now, subsequently were you promoted?
no, my lord.
No.
No, I'm hanging, my lord, at present, my lord. So I have come before you, before this honorable court, my lord, challenging that promotion order. Promotion order is an excerpt 4, my lord. At page 28. The person below me who was promoted, my lord, you will also will find by at page 30, my lord. Oh, that is the order of promotion.
You're
I've said-
challenging this order.
My lord,
You're challenging this order.
yes, my lord. Both this order has been challenged, my lord. And they all the promoters are party here,
Who represents them?
my lord.
Who represents them? Who represents the private respondents?
Private correspondence already affidavit has been filed and a reply, I submitted reply also.
J. Borman and D. Boro.
During consideration of promotion, my lord, there was no pending inquiry, my lord. So the law is that, my lord, if pending inquiry is not there, even if pending inquiry is there, my lord, then seal cover system that would have been applied. But here in this case, clearly there was no proceeding, my lord.
Now, according to you, all these persons are your junior.
Yes, my lord.
But you are entitled to only one post.
Yes, my lord. But
So why are you challenging the promotion of all of them?
my lord, all have been made party, my lord. Immediately my junior was, my lord, your lordship will find at page 30, Biplab Datta Chaudhary.
He is not promoted.
He is promoted, my lord. Biplab, your lordship will find at annexure 5, page 30, my lord. Serial number 2 in this order. And he is a respondent number 10.
No, page 28 is one order you are challenging.
Page 28 and another order, my lord, that is at page 30.
Page 30 also.
Annexure 5. 2 orders were passed.
Passed on the same day.
Same day. Why 2 orders?
Now, in terms of the seniority list, who is the person immediately below you?
Biplab Datta Chaudhary.
So you are putting a challenge to this person's order.
His name appears in serial number 6 of the seniority list at page 25.
Serial number
5 million.
5 at
Page 25. My name appears at serial number 5 and Biplab Dutta Chaudhary's name in
serial number 6.
6.
This is the seniority list.
Yes, ma'am. On the basis of that consideration was made, and though there was no pending inquiry, my lord, I have been deprived of promotion. This is the case, ma'am.
And affidavit, what is the stand here?
There is nothing, my lord, regarding inquiry also, my lord, they have stated, admitted, my lord, this was done subsequently. One so cause notice was issued on 15 to 21. Thereafter,
Where are the rules? Bank rules, service rules?
service rules, my lord, Apex Bank rules, Assam Cooperative Apex Bank Limited. Staff rules 1918.
Is it available here?
Yes, I have. It is not annexed, my lord.
That will need a copy of that. Mr. Goswami, please furnish
Lordship.
sufficient copies of the
Lordship.
rules?
Entire rules, Lordship.
Service rules.
Lordship.
When can you do it?
Lordship, after vacation, any date, Lordship?
Vacation, before vacation, my lord, is simple. Yes, my lord.
Let us have it on 18th.
18. Lordship.
18 September.
Lordship.
You provide the rules.
Lordship.
Third, Mr. D. Chaudhary, Learned Counsel for the parties. Mr. V.K. Goswami, and its senior government. None represents the private respondents. Stop. The pleadings have been exchanged. For deciding this issue, the service rules governing the services of the petitioner and the private respondent would be necessary as the question before this court, as the challenge before the court is non-consideration of the petitioner for promotion to the next higher post of
Grade D.
Grade D.
Grade D.
D for Delhi.
Yes.
Grade D. Stop. As agreed to, let this matter be listed again on 18th of September. Mr. J.K. Goswami, Standing Counsel, so-and-so bank, will furnish sufficient copies of the service rules before the court.
Much.
Adeg is on legs, my lord. So the matter may be passed
Pending the
on.
other is complete, my lord. We can have it after vacation.
Pleadings, it is submitted that the pleadings are complete here. The matter. Both parties submit that the matter be listed for hearing after vacation. Matter be listed for admission hearing, second week of November. April 2025.
Discretional pleadings are complete. And I
Fixed matter,
pleadings are complete.
you have fixed it?
Yes. We taken out after vacation for final disposal on a clearing day. Taken up.
You have fixed it today.
Just fixed for senior advocate was there for some difficulty to.
Mr. B. Purkayastha, counsel for the petitioner, submits that the matter be listed after vacations. Mr.
You Ghosh on behalf of DP Bora, Lords.
You Ghosh on behalf of DP Bora. Does not object to this prayer made. It is submitted. Pleadings are exchanged.
Yes.
Place this matter in the month of November.
Much obliged.
Please, Your Lordship. Matter regarding my lord suspension. The suspension order was of 9/10/2024, my lord.
Yes, who's for the finance?
Mr. B. Chaudhary always used to appear.
Any affidavits filed?
Yes, yes, my lord. They filed their opposition and I filed my reply.
What is the status of the proceedings?
My lord, after that, after order on fifth, they have given their review order on 17. So-called notice on 17th of March 2025. And the petitioner has submitted his reply on the stipulated time, that is on 27th of March 2025. Then from that onwards, March onwards, there is nothing has been done, my lord, and it's going to be 1 year.
You were placed under suspension when?
9/10/2024.
Heard Ms. N. Gogoi, learned counsel for the petitioner, and none represents the finance department. Petitioner is agreed. Due to the suspension, interim suspension dated so and so, issued pursuant to which the petitioner has been kept in suspension from the office of, he's serving as
It's junior assistant, my lord.
junior assistant
Yes.
in the office of the Commissioner of Taxes.
So senior assistant, so yes, my lord.
Senior assistant in the office of Commissioner of Taxes, Dhubri. Stop. It is submitted that the petitioner was suspended by order dated 9th of October 2024. And since then he has been placed under suspension. Stop. Subsequently, on 17/3/2025, departmental proceedings were initiated and the show cause notice was issued, to which the petitioner also filed his reply. Stop. Thereafter, no intimation has been received from the department with regard to the status of his status of the proceedings, and the petitioner is continuing in suspension. His suspension is being continued without any review. Stop. In the affidavit which was filed, there is no averment as to whether the suspension was reviewed either prior to issuance of the show cause notice or after the show cause notice. Stop. As per the office memorandum dated so and so, issued by the government of Assam, issued by the Department of Personnel, a detailed procedure is laid down in respect of matters in for the various departments to proceed in cases where suspension orders are issued in respect of delinquent employees. Stop. The affidavit filed does not reflect that the steps prescribed under the OM dated so and so have been followed. Stop. Under such circumstances, we direct the respondents to apprise the court as to what steps have been taken pursuant to issuance of the show cause notice dated so and so on the writ petitioner, and whether any review for continuation of the petitioner under suspension was carried out. Let this exercise let these information be placed before the court on the next date fixed. 22nd September.
26.
22nd September.
I will place to me.
May I please, O Lord? That matter pertains to non-payment of minimum pay scale, my lord. My lord, petitioner is a casual employee, my lord. Fairly low, she pays 13, my lord. Pays 13, my lord. Deputy Commissioner, my lord, Morigao, my lord, forwarded the name of 4 persons, including the petitioner, my lord. Next page, your lordship will find name of 4 persons for grant of minimum pay scale, my lord, in terms of judgment of open draft, my lord. But subsequently, nothing happened, my lord. Then petitioner filed a writ petition, my lord. Writ petition was disposed of, your lordship will find page starts from page 16, my lord, and operative part page 18. Petitioner was granted liberty to file a representation, my lord, before the authorities, my lord. Then, my lord, other person, my lord, Panjabarat Chauhan, my lord, who was also forwarded, he also filed a writ petition, my lord. Similar order was passed, my lord. Then, my lord, Panjabarat filed a contempt petition, my lord. As he filed contempt petition, my lord, his benefit was granted, my lord. And in this case, in the contempt petition, my lord, the respondent filed an affidavit, my lord. Your lordship will find page 27, my lord. Page 27, my lord, paragraph A, my lord.
Paragraph?
Paragraph A, my lord. A.
Paragraph 4. 4A.
4A, yes. That in pursuant to the order dated so-and-so passed by this honorable court in so-and-so, the Revenue and Disaster Management has taken necessary steps to expedite the matter. The proposal of the Deputy Commissioner Morigao for payment of minimum pay scale in respect of following 4 number of casual workers, including the petitioner of the instant case, received by letter dated so-and-so of the Deputy Commissioner Morigao was processed in the Revenue Department, my lord. Then 4 persons name, my lord. Petitioner name Abdul Sattar, my lord. But his case has not been considered till today, but the Abdul Sattar has been granted benefit, my lord, because he filed contempt petition. And his petitioner case is still lying pending, my lord, in the Finance Department, my lord.
Yes, finance. You consider this matter?
Lordship.
For whatever reason, if the officers are responsible, you pass appropriate orders for delay.
Or Lordship may, alternatively, Lordship may direct me to obtain the instruction also why this case has not been considered.
Heard counsel for parties, the respondents will Respondent Finance Department to apprise the court as to why the case of the petitioner has not been considered in terms of the order dated 3/6/2022. What is your name?
Abdul Sattar.
Abdul.
Ah, so you had already filed, there's already a direction,
Yes, my lord.
3/6/2022.
Yes, my lord.
As
Although
per the affidavit of the department lordship, 4 names were forwarded. 1 has been approved, remaining are still under consideration.
it is submitted that 4 names were forwarded by the department, out of which 1 name was approved, and the names of the petitioner along with others were not approved. Mr. P. Nayak, K. Nayak will obtain the required instructions in the matter. Additional AG, Mr. S. Dr. for the Revenue Department. The list on 15 October.
Lordship.
15 October.
Published.
Your Lordship, on the last occasion, Justice P.K. Mushahari was appointed as the sole arbitrator. This is his official concern letter.
In deference, pursuant to the earlier order dated 20/08/2025, whereby Justice P.K. Mushahari, former judge of the Guwahati High Court, was appointed as prospective arbitrator subject to furnishing of the written declaration, the section 12(1)(b) of the Arbitration and Conciliation Act 1996. Justice P.K. Mushahari, former judge, Guwahati High Court, has furnished a written declaration expressing no difficulty or handicap in conducting the arbitration if appointed by this court. The said written declaration is placed before the court and is kept in the case record. Under such circumstances, the order passed earlier dated so and so by this court stands confirmed. Justice P.K. Mushahari, within bracket retired, former judge, Guwahati High Court, is appointed as the sole arbitrator to arbitrate and resolve the disputes arising by and between the parties, arising relating to contract agreement number so and so, it will order to find them. So and so, stop. Let the parties appear before the arbitrator appointed on 26th of September. Registry to communicate the order passed today to the arbitrator appointed, learned arbitrator appointed, Justice P.K. Mushahari, retired, former judge, Guwahati High Court. Yes. This post.
Madam President. Lordship, this is a section 11(6) application. Now, here, the core issue, Your Lordship, I'll place the facts, Your Lordship, because we demanded for the arbitration There is a dispute, they have raised a dispute with regard to the mode of manner of invoking the arbitration clause. That is the core issue. But prior to that, I'll just place, because of railway specific, there are some procedures that within, we first have to make a demand with regard to this. Now, for that purpose, your lordship may kindly come to the arbitration clause, which is at page 74, your lordship. If your lordship has got it.
Yes.
Now, as per this arbitration clause 64, it starts with clause 64 is at page 75. Here, if I may read out, your lordship. In the event of any dispute or difference between the parties hereto as to the construction or operation of this contract or the respective rights and liabilities of the parties on any matter in question, dispute, difference or any account, or as to the withholding of the railway of any such and such, may claim to be entitled to, or if there fails to make a decision within 120 days, then in such case, except for in any accepted matter referred to clause 63 in this condition, the contractor after 120 days, but within 180 days of his presenting his final claim on disputed matters shall demand in writing that the dispute or difference be referred to arbitration. So the first and foremost thing is, your lordship, is we have to first raise the final claim, and thereafter, if the respondent, that is the railway, fails to respond to it after 120 days of my submitting of the final claim, then I have the duty to invoke the arbitration clause in writing for seeking an appointment of an arbitrator. That should be within 180 days from the date I had raised the final claim. That is, after expiry of the 60 days thereafter. Now, here in this case, your lordship will find Annexure L at page 159 is the final claim which we had raised, your lordship. Annexure L at page 159. Here, we had raised our final claim with regard to various disputes, and the details of the claims it was given by the claimant in page 160. Thereafter, your lordship will find the respondents reverted back to us to make some changes to the claim which we had made by annexure M1, page 161. Thereafter, again, we responded to that request, and we filed a modified thing with regard to the PVC bill and the non-payment, etc., page 162 at page M2. Then here the dispute starts, your lordship, annexure N1, page 164. Now, as per the requirement, as your lordship had seen, that we were to raise and invoke the arbitration clause within 180 days if they fail to respond to this. Here we had issued this particular notice under section 11 of the Arbitration and Conciliation Act, seeking appointment of the arbitrator. This was there. The respondents, after receipt of this, gave their reply in page 168 at annexure O. Their only contention is that my request for seeking appointment of an arbitrator is not being considered because I have not specifically mentioned clause 64 in my said notice, invoking the arbitration clause. But this is the whole dispute, and in their affidavit.
Which clause you are referring to? 64?
Yes, your lord.
What does 64 say again?
64, your lordship will find 65, 75, your lordship. In the event of any dispute or difference between the parties hereto as to the construction or operation of this contract or the respective rights and liabilities of the parties on any matter in question, dispute or difference on any account, or as to the withholding by the railways of any certificate, to which the contractor may claim to be entitled to, or if the railways fail to make a decision within 120 days, then in such a case, except in any of the accepted matter referred to in clause 63 of this condition, the contractor after 120 days, but within 180 days of his presenting his final claim on the disputed matter, shall demand in writing that the dispute or difference be referred to arbitration. So here the question is, it is not in dispute that section 21 notice in compliance with section 21 was not issued.
Where is that notice that you had referred to just now? 156,
Yes, sir.
156.
160,
164, Mother.
164 is the letter.
159.
Yes.
What is 159? Final.
159 is the final claim because in the, as per the GCC of the railways, I have to raise my final claim. And thereafter, if the respondents do not respond to the final claim within 120 days, then I, within 180 days of my filing of this final claim, will have to make a demand to them for seeking an appointment of an arbitrator. That is the whole concept. 120 days, within they have to respond. If they fail, then I,
120 days from
filing of this claim, they have
3rd of
to make
May.
a response.
3rd of May. All right.
So if they fail to, this demand which we have been raising, if they fail to make the requisite payments, then I, being the contractor, is required to make the final demand of arbitration within 180 days from this particular date. Here, it is not in dispute that I had complied with all the prerequisites that within 180 days.
180 days will expire when?
180 days.
3rd of November.
It is 510, 120. I made the demand within 154 days. As per this, it should have expired in, it was in 24th. May, June.
3rd of November.
3rd of November. And I raised the demand on 5th of October. Now, their contention is not that I have crossed the deadline or something of that. Their whole contention is, if your lordship sees the letter and annexure O at page 168, they take the plea that I have not specifically mentioned clause 64 in that said application. I had merely referred to section 11 of the Arbitration and Conciliation Act. So a demand for arbitration is specifically stated. My contention, your lordship, is a section 21 notice as contemplated is of substance, not a form. Here, the intention of the parties is to be looked into. And here, the intention, they fully know by their response that they know that by this letter of ours, we had sought for an invocation of the arbitration clause. And they are taking a technical plea that section 64, clause 64 was not mentioned in the notice. So that is the whole thing. Even in the affidavit, they have taken some points with regard to the merit of the disputes, but the main contention is with regard to the form of the notice issued by us making for the final demand, your lordship.
So you should have made it by 30th of October.
Yes. It is within time. Everything was done, your lordship.
How is it within time? Within 160 days? From May 3rd?
From the 3rd, it is October, November, the 3rd of November.
No, not 3rd of November. 180 days.
Yes.
You have to calculate from May.
Yes. Your lordship will find because they had
It expires on 30th of November, 30th of October.
30th of October. It is on 5th of October, I've raised.
Huh? No, demand for arbitration. Where is the
Demand for arbitration is October 5th,
Where? Page number?
164.
Okay. 164.
Annexure N1. This is the demand, your lord.
All right. So this is within time.
It was within time.
Then
the only thing they are taking is in this particular demands, I have not referred to clause 64. I have only stated arbitration, arbitrator and section 11 of the arbitration.
How is it material?
That is the thing.
Clause 64 does not say so. But does clause 64 indicate that in your demand, you must refer clause 64?
No, my lord, the other requirement is, my lord, that clause 63. My lord, it says, my lord, first the representation should go to the GM. My lord, page 59, May 3, 2024 letter, which has been pointed out, my lord, at page 59. That representation is addressed to the chief engineer. So, my lord, the first representation before
Clause 64 is arbitration.
Yes, before 64, my lord,
63 are only accepted matters.
No, my lord, 63, if I may read, my lord, 63. No, it says all disputes and differences of any kind whatsoever arising out of or in connection with the contract, whether during the progress of the work or after its completion, and whether before or after determination of the contract, shall be referred by the contractor to the general manager, and the general manager shall within 120 days after receipt of the contractor's representation make and notify decision on all matters referred to by the contractor in writing, provided that the matters for which provision have been made in clauses 8, 18, 22, and so forth, my lord, of the GCC or any clause of the special conditions of the contract shall be deemed to be accepted matters, and the decision of the authority thereon shall be binding and final and binding on the contractor, provided further that the accepted matter shall stand specifically excluded from the purview of the arbitration. Now, my lord, comes this clause 64 1.1, which says that in the event of any dispute or differences between the parties hereto as to the construction or operation of the contract, or the respective rights and liabilities of the parties on any matter in question, dispute or difference of on any account as to withholding the railway of any certificate to which the contractor claimed to be entitled to, if the railway fails to make decision within 120 days. Now, this decision is referring to, my lord, clause 63, that is representation to the general manager.
So under 63, what is to be done? Any differences, you refer it to the general manager.
Yes.
Then?
If the general manager fails to, my lord, take decision within 120 days, then within the outer limit of between 120 and 180 days, my lord.
And what happens if the general manager takes a decision within 120 days?
My lord, then if the party is still dissatisfied, my lord, they can still come for arbitration.
Where do you say that? Reading 63 and 64, how do you come to a conclusion that in spite of there being orders passed by the general manager, if further disputes remain?
My lord, if I may read from the middle, clause 64 1.1, I am reading, my lord, in the event of any dispute.
So you read 63 first.
Yes, my lord. My lord, 63 says, my lord, all disputes and differences of any kind whatsoever arising out of or in connection with the contract, whether during the progress of the work or after its completion, and whether before or after the determination of the contract, shall be referred by the contractor to the general manager, and the general manager shall within 120 days after receipt of the contractor's representation make and notify decisions on all matters referred to by the contractor in writing, provided that the matters for which the provision has been made in clauses 8, 18, 39, 55 of the GCC or any other clauses of the special conditions of the contract shall be deemed as accepted matters. So in case of accepted matters, my lord, no decision is required to be taken. And in other cases, my lord, the manager has to decide and notify the decision on all the matters. And the decision of the railway authority thereon shall be binding, final and binding on the contractor, provided that the accepted matters shall stand specifically excluded from the purview of the arbitration clause.
What are accepted matters?
Accept matter has been defined here.
My lord, it is defined in clause.
Anyway, it does not fall under accepted matters.
No, none is
No,
there.
no, not.
That is not in dispute.
Then what happened to the decision of the general manager? Has any decision been taken?
No decision.
No,
The
no,
last-
no representation has been made to the general manager. That is.
Your last
Because
letter
that
may be
pre-
looked into.
pre-arbitration-
Annexure O, page 168.
160.
Here, one Mr. S. Sengupta, Deputy Chief Engineer for the General Manager, has responded to this. He has stated regarding appointment of an arbitrator in dispute, while referring to my last letter seeking invocation of the arbitration clause. He says that in reference to above, we have submitted a notice under section 11 of the Arbitration and Conciliation Act for the appointment of an arbitrator. As per contract agreement, there are clauses for appointment, is clause such and such. But in this case, you have submitted notice under section 11. And in view of your demand for appointment cannot be entertained. So he, on behalf of the general manager, has rejected the application seeking appointment of an arbitrator on the
Where-
ground that
Page number?
page 168. This is the last letter. After my final demand was made, the deputy chief engineer contract for on behalf of the general manager wrote this letter, saying that because I have not specifically mentioned in my demand letter that clause 63 or 64, my application, my prayer for seeking appointment of an
168 only says that you submitted section 11 notice, notice under section 11 instead of submitting under
clause this. That is their stand. So my contention is a section 21 notice, which it is contemplated for invoking an arbitration clause, is a matter of substance, not of form, your lordship. And the intention.
It's not, their objection is you did not follow 63. Before you resorted to 64.
I had followed, they say that because at that point of time, general manager, it was not specifically addressed to the general manager.
Is 159.
159, that is there. But section 11, when they had responded, it was not on the ground that I had not invoked this under section 63. I had not
No.
followed. The ground was that I had invoked section 11 of the Arbitration and Conciliation Act, not with regard to that.
Now, Mr. Gupta,
Hello.
section 21 notice you have received.
Yes, ma'am.
It was open for the railways to resolve the dispute
But not the
by
pre-arbitral.
invoking 63. You could have treated this to be 63.
No, my lord, the requirement under the agreement is twofold, my lord. First, the pre-arbitral process to make a representation to the general manager, that is mandatory, my lord. That has to be crossed, and then if the general manager rejects the claim or fails to decide, then the question of clause 64 comes, my lord. So that before approaching for arbitration or giving a section 21 notice under 64, the pre-arbitral process as laid down in the contract agreement, my lord, that has to be complied with by the parties. That pre-arbitral process has not been complied, as the representation, my lord, clearly reveals that it has not been sent to the general manager. So, my lord, the very invocation, the subsequent notice would also, my lord, be of no consequence, because the pre-arbitral process as laid down in the agreement has not been
Any
followed.
authority that this process, unless mandatorily followed, arbitration cannot be invoked, notwithstanding that it is a part of the agreement.
Yes, my lord.
The purpose of arbitration is to sort out disputes.
My lord.
they may not have strictly followed 63, but once you have received a notice under 21, it could have been treated to be a notice under
The
63.
grievance has been addressed to a wrong authority, my lord. Because, my lord, if this be allowed, my lord, arbitration, my lord, we have no dispute with that, the matter should be referred to arbitration. But the invocation should be proper, my lord, to the correct authority.
Show us any authority on that.
My lord, but at the moment, my lord, I have, my lord, I'll pray for some time, my lord, so. There are authorities, my lord.
But your lordship, with due respect, here, the one letter by which they have rejected, it is for the general, on behalf of the general manager, it has been rejected. And they have never taken the plea that the initial demand or final claim was not addressed to the general manager, the last letter by which my invocation has been rejected.
No, that is what they are saying. You have not resorted to 63, 64.
They say that I have not referred to, but your lordship will read that 63, 64 is merely the clause under which I can seek for an arbitration. But if your lordship sees the clause at page 63 itself, at page 970, 77, clause 64.7, it clearly refers to the Arbitration and Conciliation Act 1996, that the said proceeding will be governed by this Arbitration and Conciliation Act.
No, the question is not that. The question is the arbitration agreement or reference for arbitration is a matter of contract.
Yes.
There is no separate arbitration contract. It forms a part of the main contract. Now here, before invoking arbitration, there is a responsibility, or at least this is their claim, that the responsibility is cast under 63.
Yes.
That you invoke 63, only if there is no resolution
Response
under
within
63, you go to 64. So whether you can bypass 63 and invoke 64 to say
yes
that it is not mandatorily required to be invoked, or it is binding on you.
Because your lordship will find that this by section Alexia L, though the final claim was made by us addressed to the chief engineer, though it is undoubtedly not addressed to the DM.
Give us some citations, give us some authorities on this issue.
Or
That
my
will
lord,
be
they
okay.
can address to the GM, my lord, we can. That also.
But the time is already over.
Counsel for the parties have urged the respective have made their respective submissions. Matter be listed when we want it.
Any date your lordship will fix, your lordship.
Before the vacations?
If possible, your lordship, or after vacation, as your lordship is convenient, your lordship.
It is convenient to me any day. You tell us when you want it. 16, 17, 18, 18th?
18th, your lordship.
18th September. Council would like to place judgments in support of their arguments based on 18th. As agreed. Yes, it's fine.
We have filed the affidavit, lordship. The NOK has not been submitted by the deceased, that means heirs, lordship. Heirs of the deceased.
My lord, regarding.
And the title suit is also pending, lordship, between the parties.
My lord, it is the, regarding NOK, the mother-in-law, that is the respondent number 8, there is objection that is why not issued. And in my petition, the petitioner herself admitted that my mother-in-law regarding the benefits, service benefits, I have no objection to share. Already written in the petition, my lord, and
Mediation, go ahead. Mediation.
May I please, your lordship? I am for respondent number 8. We need some more time to file the FP.
Lordship can send it for mediation also, Lordship, because this is between the two private parties, Lordship. We have no objection to that. Because the legal heirs definitely
Who's, respondent 8?
mother-in-law.
Mother-in-law. The petitioner is otherwise married. I mean, legal wife.
Widow,
Independent.
yes, Lordship.
Legal wife.
Widow of the deceased.
Then what stops the petitioner from getting the pension?
Lordship,
per the rule.
the NOK, because otherwise it cannot be processed, Lordship.
Is it?
Yes,
After
Lordship.
the amendment?
Yes, Lordship.
In the amendment, my lord.
Because these are the vital things we have stated in our affidavit, Lordship.
No,
Page
NOK
48, paragraph
Is
4.
an NOK required?
Yes,
This-
Lordship.
This is compassionate family pension.
Compassionate family pension, because the mother, she is also claiming a proportionate share, Lordship, that's why. And she has filed a title suit also, Lordship.
Where is the scheme here? Compassionate family pension?
Scheme, my lord, that is page 20, my lord. Relevant portion, my lord, 21 page, my lord. Roman clause 3.
Now the respondent number 8 has filed one title suit.
Where is the NOK mentioned here in the?
Not mentioned, my lord, in the
Then
scheme, my lord.
why NOK is required? In the title suit, is there any injunction?
No injunction, my lord.
Lordship, in page 52, we have a communication. Page 52 of the affidavit in opposition, Lordship.
Next of kin certificate.
Yes.
Next of kin certificate, you have not taken out.
My lord.
Why?
That's because, my lord, mother-in-law filed objection, my lord.
This Lordship, that's why.
Filed objection before the DC.
Yes, circle officer, my lord.
Circle officer.
And the local panchayat also not issued the legal year certificate regarding that relationship. And service book is also, my lord, department supplied to the petitioner, and that is also annexed, my lord. In the service book, it is clearly stated that petitioner is the legally married wife.
Where is the service book?
Service book, my lord, in RTI reply, my lord, it is page 32, my lord.
And where is your name?
My lord, first line, wife, Srimati Prabhavati Rai. And vernacular at says, my lord, 35.
In 35, nomination is given to two lordships, Srimati Gomati Bala Ray, mother, and Srimati Prabhavati Ray, wife. Both are there and nominated to get the death return, which is lordship.
And regarding death come retirement benefit, petitioner has no any objection to share with
But
mother.
regarding non-issuance of NOK, you have not filed any You are not seeking orders against the office of the circle officer?
It is process is going on, my lord. Some time may be required.
Then you
Maybe.
file it.
My lord.
Counsel for the parties, the petitioner submits that he is in the process of applying for the NOK, next of kin certificate from the concerned office of the circle officer. MSM Bhattacharya appears for the additional government, senior government advocate appears for the state. MS S. Pal appears for respondent 8. MS A. Sharma for respondent number 3. Let this matter be listed after 6 weeks.
Not for vacation immediately, man.
6 weeks. You apply and come back.
Hello. Obliged.
Deeply obliged.
Item 67.
My lord, would have a look at the last order. My departmental statutory appeal was pending, my lord. So at this stage, I would, since there is no disposal of the appeal, I would pray that the writ petition can be closed, my lord, by asking them to
Yes,
consider that.
I have sought for instruction, but I have not received instruction. Otherwise, I have filed my affidavit, but now they want to prefer that.
Now, if the appeal has already been disposed of, then
We have not been communicated. Had it been disposed of, my lord,
That
we
is
would have.
I have sought for, but I have not yet received that instruction.
then we close it with this simple direction.
My lord.
Lord, if not disposed of.
Heard. Learned counsel for the parties. The petitioner is aggrieved that has
Come to page 29, annexer 5.
Page
29, annexer 5. Appeal under section 139 of the Assam Rifles Act.
No, what is your prayer here?
My lord, I am seeking
Praying for
it's an appeal against the
challenge has assailed the order of dismissal
dismissal.
dated 1st of October 2024, passed by the respondent 3, dismissing the writ petitioner from the services of which force?
Assam Rifles.
Assam Rifles.
Assam Rifles. Stop. Against the order of dismissal, as per the rules, the petitioner preferred an appeal. Stop. Although the writ petition is directed against the dismissal order dated 1st of October 2024, upon apprising the court that an appeal against the order of dismissal has been preferred, but no orders have been passed in the appeal, the learned CGC was asked to obtain required instructions in the matter. The learned CGC submits that she has applied for, she awaits her instructions. Although she is sought for, she is still awaiting for her instructions. The learned counsel for the petitioner submits that notwithstanding the dismissal order being assailed in the present writ petition.
There's also my alternate prayer at page 17. That the appeal may be considered.
Page?
So see page 17, my lord.
17.
17 of the writ petition.
This is for setting aside the dismissal order.
Annexer 5 is the appeal, my lord. Page 1717. Good. The second part.
Setting aside the dismissal order and alternatively seeking a direction to the respondent number 2 to consider the appeal dated 2nd of December 2024 within bracket annexer 5. It is submitted that since no instructions are forthcoming from the respondents, the writ petition can be closed with a direction to the respondent number 2 to dispose of the appeal filed with the petitioner on 2nd of December 2024, if not already disposed of. In the meantime, stop. Considering the limited prayer made by the petitioner, not objected to by the counsel for the respondent, this court is of the view that the writ petition can be closed at this stage without expressing anything on the merits of the case. Stop. The respondent number 2 will ensure that the appeal preferred by the petitioner on 2nd of December 2024 is disposed of as expeditiously as possible. within a period of 30 days.
No, Lordship, 6 weeks.
All right, 60 days from the date of receipt of a certified copy of this order. Stop. If during the pendency of the writ petition, the appeal preferred by the petitioner has already been disposed of, then a copy thereof shall be served on the writ petitioner. Stop. With the above observation, the writ petition stands disposed of, closed. Interim, if any, stands merged, pending ayes are also dismissed. We'll come back in the second half. Mr. Goswami, you will take up your matter. Yes.
My lord, I have challenged the minutes of the SLC, my lord. My case was recommended by the DLC against clear vacancy, my lord, page 19.
So now in view of this notification, what is the position?
My lord, your lordship directed me to apprise the honorable court about the outcome of the challenge made regarding the 18/9/2024. Thereafter, this honorable court has directed that all the pending cases as on 3/4/2025 shall be considered, my lord. Those who have challenged the subsequent notification. But my case was filed before issuance of the notification. And the SLC has rejected my case that there is no vacancies. But as per clause 15 of the OM 2015, if there are no vacancies of a particular department, the department can consider in respect of other departments. And this is the order, my lord. And the batch of writ petition has been disposed of, directing that all the pending cases as on 3/4/2025 shall be considered. It was consensus made by the Advocate General before the honorable court. And thereafter, number of writ petition has been disposed of.
No. Pursuant thereto this 30th of August.
Yes, my lord. There is a direction that we have to submit our documents. Last that is 15/9/2015, 25. And clause 11. There is a clause 11.
What directions do you want now?
To direct the authorities to accept my particulars.
As per the executive order. That's
Yes.
all. Are you challenging the executive order?
No, my lord. I have challenged the OM, minutes of the SLC, page 26. Just have a look.
No, Mr. Sharma, you're not understanding. Or maybe you don't want to understand, I don't know.
No.
You see, pursuant to the 18/9 notification,
Yes.
Some orders were passed, disposed of. Now there is an executive order.
Yes.
It lays down a procedure.
Yes, ma'am.
So your case will be considered as per the procedure. That's all we'll say.
Yes,
And close it. You file whatever papers are there.
Since my SLC minute has not been interfered with.
No, the SLC minute not been interfered will have to be decided now in terms of the executive order. This executive order you have to go through and tell us what is it.
But as per executive order, those who have challenged to the OM, their cases will be considered.
Correct.
Since I have not challenged and my writ petition has been filed in the year 2023 and OM has been issued in the year 2024, there was no question of challenging my.
So therefore, this will now have to be considered whether as per the OM is it to be considered or this OM needs to be watered down or interfered.
My prayer is.
We can't ignore this OM now.
Yes, my lord. On merit, my lord, you lordship may consider my application.
On merit, we'll hear you.
And since the last that is my lord.
There can't be help now. You want a disposal and you want a disposal before 15 and interpreting this OM without even putting this challenge to it.
There is a order, my lord, you lordship just a look, my lord. Page 27.
Prior to the executive order.
Yes, my lord. Prior to the executive order, there is an order passed. They are in the minute.
They have now laid down an SOP.
Yes,
in terms of your SOP, we'll direct that your case should be placed and considered.
Because my case will be not covered because I have not
If it is
challenged.
not covered, then you'll have to assail this and say on what grounds this SOP is not required to be applied in your cases.
Even ignoring that SOP, my lord.
We'll not ignore it. Why should we ignore it?
Because my case was pending before that.
It will have to be heard, Mr. Sarwan. Heard counsel for parties, pleadings exchanged. No.
They have not filed
We are-
affidavit with them.
The counsel for the respondents will complete their pleadings, matter be listed again in the month of November.
I have to.
Hmm?
October, after that.
October 28th. October.
I think 36 and 37.
He left over.
Yes. Lordship, before Lordship issuing the executive order, Lordship, one notice was also published, Lordship. Same day also, Lordship. 30 August also.
We will direct your case to be considered in terms of the SOP laid down in the executive order. Is that all right?
Lordship, I am selling in 18/9/2024, Lordship. In that call, Lordship, may I read, Lordship? In compliance of the order dated 3/4/2025 passed by the Honorable Guwahati High Court, Guwahati in WBC so and so in the matter of Abul Kabir so and so regarding appointment on conventional ground, the Government of Assam in Personnel Department hereby invites a petitioners who have challenged the office memorandum so and so, including those similar cases which has been disposed of by the Guwahati Honorable High Court, citing the judgment and order dated 3/4/2025 passed by the Honorable Guwahati High Court, Guwahati, WBC number so and so, the date of
Now,
publication
this
of this
is
notice.
asking you for the particulars
Yes, Lordship.
and to be decided in terms of this executive order.
Was it till till publication of this notice, Lordship? Notice was published on 13 August, Lordship. My case was filed on 6/5/2025, Lordship. In this regard, Lordship.
That's what that.
That is to be considered in terms
This
of the
case was
executive
the
order.
182 of the executive order of 30 August.
Was it coordinate by bench already disposed on similar matter, Lordship? Monjulta Goyari case. The same matter was disposed on 3/9/2025, Lordship.
Let us see. I have a copy here.
Kindly, my matter may be disposed on the same matter, same line, Lordship.
Yes, Honorable. So I don't think the executive order has been addressed in the order.
Notice was is this also. Last left, we go.
No, it cannot be placed, no?
Same date notice. Is supposed to.
So what is this order, Mr. Borua? Have you seen this order?
Just now I'm seeing.
9/25?
3/9.
No.
This is just now I'm seeing, Lordship, but this executive order is not been.
Notice was mentioned, Lordship.
On
the same day,
placing the
notice-
case before the SLC and submit all the, does not arise, Lordship.
No, Lordship,
If
same
it
day,
is-
Lordship.
if it does not arise, then you need to bring it to the notice of the court.
And perhaps.
Your
in-
colleague
In
represented,
the matter, Lordship, this executive order was not been properly been placed.
we don't know. This is an order passed, whether
With a single
petition was
yes.
disposed of, he is seeking a similar order.
So only my limited period to direction may be given to place my matter before the next SLC.
No, it
No,
cannot be
cannot-
done. Please try to understand, it cannot be done in view of these orders. Don't ask for an order which is not capable of being passed. It cannot be done.
Yes, Lordship, as per notice, Lordship, till
Notice is there, you go and file whatever documents you want, you file it as per notice. But thereafter, it shall not be placed before the SLC. It will be considered in terms of the executive order.
Lordship already disposed coordinate bench, Lordship.
We don't
Praying
know.
for similar relief, Lordship.
Yes, Mr. Burwa,
Lordship, thing is that his case will not fall under point number.
don't give us all these arguments. Tell us whether this order 3925 is passed in similar circumstances or not.
No, not in similar
How
circumstances.
do you know that? Reading this order?
Similar, 18-9 Lordship.
Mr. Nath, what is this? There are orders being passed. Your councils are not aware of what orders are being passed.
Well, the
Sorry, to 18-9 challenge question.
executive order was not, in the meantime, it was issued on 30.
No, kindly see.
Lordship.
Kindly see.
And a notice was also issued, my lord.
Notice
on
and
the same day.
executive order were passed on the same day.
Same day. And notice was published on 31st of August, my lord. It was published in 7 newspapers.
Please read the order.
Lordship.
We are disposing of your matter with the direction that in terms of the notice published, whatever documents you want to furnish, you furnish. Thereafter, the SOP in terms of the executive order shall be followed. All right? Okay, heard. Counsel for parties.
The date is-
The petitioner is before the court.
What is going to
Is your case was rejected by the
No, Lordship. My already recommended by the DLC, Lordship.
and SLC did not consider.
Not yet placed, Lordship.
Was not considered by the SLC, although the same was recommended by the DLC. By its minutes dated so and so. Stop. While the matter was situated thus, the government issued the notification dated 18/9/2024. And the case of the petitioner, therefore, was never placed before the SLC. Several writ petitions have been filed before this court. And in pursuance thereto, the government has published an executive order number so-and-so dated 30th August 2025, where a standard operating procedure for disposal of matters of compassionate appointment have been laid down. Stop. On 30th of August also, a notice was published by the notice number so-and-so, whereby the particulars mentioned in the notice were sought for from the applicants who are seeking their consideration for appointment on compassionate ground. Stop. The last date for submission of these information as per the notice is fixed on 15/9/2025. Accordingly, the petitioner is permitted to furnish his notices, details, in terms of the notice number so-and-so dated 30th August 2025 before the concerned authorities. Stop. The authorities thereafter will proceed to consider the case of the petitioner in terms of the SOP dated 30th of August 2025. Writ petition accordingly stands disposed.
So item number 30.
There is also, how many writ petitions are there?
3 writ petition also.
In all the matters,
I'm challenging the office movement of 18/9 also. All cases DLC recommended and still pending before the
all
SLC.
right, disposed. What are the item numbers?
36, 37 and 38. also.
36, 37, 38. Yes.
All right.
Pending item 40.
Now, why don't we call the complete this? এইখিনি পিছত মাতি দিব. We'll call it up after a while.
Supplementary for motion item 63. May, please, my lord. I seek your lordship's leave to address through VC minutes.
Yes.
I'm grateful. Minutes, item 63, 64, 65. And the specially mentioned production list item 1 minutes. I'm appearing in these 4 matters minutes. If I may just give your lordship a background minutes.
Yes.
Item 63 minutes is an Assam Police Service officer minute. This matter, the lordships minute, they fall at a different pedestal minutes. In fact, that case is much stronger minutes insofar as the division bench judgment is concerned. The item 63 minutes is an Assam Police Service officer. Banali, have you handed over to my lord the chart?
Yes, yes, we've got it.
If a lordship takes the chart minutes.
Yeah.
First minutes, item 63 is Jatindra Prasad Barua. He is Assam Police Service officer, my lord, 2015 batch. His date of joining is 15 September 15. His date of completion is 15 September 17. The first discharge order your lordships will see, my lord, I'm just giving it handy for your lordships, is 27/7/18, which stands quashed and set aside by the division bench. Then, my lords, the impugned discharge order is 29/7/17 at page 67. And his writ appeal before the division bench was 147 of 2020. Now, let's, insofar as the police service officers are concerned, my lords, their probation period prescribed, my lords, under Rule 15 is 2 years. That your lordships will find at page 26 of the writ petition, my lords. If your lordships just take take item 63.
Yes.
Page 26, your lordship says?
26.
Yes, my lords.
Yes.
Well, that's all at the foot of the page, para 21 minutes. Probation. All persons recruited to the service shall except persons recruited under Rule 5 to be on probation for a period of 2 years from the date of appointment of service. The period of probation may for good and sufficient reasons be extended by the governor in individual cases by such period as deemed necessary. Now let's contrast this, my lords, with page 200.
200.
Yes, 199, my lords, the division bench judgment where, my lords, the other rules, your lordships had the occasion on the earlier date, my lords, when I addressed your lordships, to see the Assam civil service rules. So Rule 15, your lordships saw 2 years can be extended. Now, please have Rule 22, my lords. Foot of page 199.
Yes.
A member of the service shall be placed according to seniority on probation for a period of 2 years. Please mark, provided that the period of probation may for good and sufficient reasons be extended by the governor in individual cases for a specified period not exceeding a period of 2 years. So, my lords, the other services, my lords, 2 years
are you
plus
covered?
2 years.
You are covered by these directions, aren't you?
Yes, I am covered. But one important thing I must point out insofar as item 63 is concerned is there is a notification of 20th January 2018. If your lordships have the chart, my lords, please have the chart, my lords. At the foot, there is a footnote. Your lordships has that.
Yes.
Though the state respondents had claimed to purportedly extend the period of probation of the petitioner Jatindra Prasad Barua by notification of 20th January 18, however, the said notification has been declared to be expressly illegal, void ab initio, and therefore not enforceable against the petitioner so as to alter his position. Please mark this, my lords, from a confirmed employee of the state to be reverted back to the position of a probationer. This your lordships will find
That
at
means,
page 2.
according to you, you are covered. You fall under the
141.1.
141.1.
Yes, my lord. And also have one more aspect, my lord. Just have 141.3.
According to you, you are confirmed.
I am confirmed. So,
you are still under probation. Is it?
Sorry, my lords.
According to the state, you're not a confirmed employee. You are.
No, state cannot take that stand because, my lords, the division bench has already ruled, my lords, that I have been confirmed. If your lordships have the directions, my lords, at page 259.
Yes.
Lordships have it, my lords?
Yes.
Accordingly, the appeal is partly allowed by setting aside the impugned judgment and order of 18/3/2020 passed by the learned single judge. Resultantly, appellants are found entitled to the following relief. Number 1, the discharge orders in respect of all the appellants are set aside.
subject to the following. Number one, those appellants who have completed their initial probation period of 2 years. And by taking into consideration the maximum extendable probation period under the respective service rules are liable to be reinstated within the period of 50 days from the date of the service. Then please come to 3, my lord, which is relevant for my lord, the police service officers.
Yes.
The notifications dated 30th, 12th, 17th and 20th January 18. My lord, my probation was sought to be extended by 28th January 18 are held to be ex officio illegal and thus void ab initio and therefore not enforceable against the concerned appellants so as to, please mark this, alter their position from a confirmed employee of the state to be reverted back to the position of a probationer. So the police service officers, my lord, stand at a higher pedestal. The court has held that they are confirmed employees. So even one Malad is square probationer. So Malad, I could not have been in any case discharged. Now please have the discharge order, Malad, at page.
Where is the order of discharge, impugned order?
Impugned order of discharge your lordships will have is at page 67.
There is no page 67 here. What is the date of the?
Sorry, Malad, it is no Malad, it's in the page 67 of the writ petition, Malad.
In the copy of the court, there is no page 67. 66, then 68. So what is
Bernali, please hand over this 67. That's the most important document. I'm sorry, Malad. That's the discharge order.
What is the date of the order?
This is Malad 29 July 2025.
This is number 11/2025/180. That's the notification.
Yes, Malad.
All right. This is number day 66.
Okay, I'm guessing 66. Please have page 66, Malad.
Yes.
Whereas in compliance of the directions in para 141.2, read with para 141.7 passed by the Guwahati High Court, Malad, this does not apply to me, Malad. In Kamal Devnath and other linked cases, the governor of Assam is pleased to withdraw the government order of discharging Jatindra Prasad from police service wide order dated 27/7/18. And whereas as directed by the Honorable Guwahati High Court, the case of Jatindra Prasad who was on probation, again wrong, my lords. High Court has held I am a confirmed employee. In Assam Police Service at the time of discharge is considered and upon consideration he is not found fit for confirmation and been a member of the Assam Police Service. Now therefore the governor of Assam in exercise of powers conferred under Rule 16B is pleased to discharge Jatindra Bond, probationer from service with effect from 27. Malad, this is in the teeth of the finding of 141.3, where Malad, I have been held to be a confirmed employee.
We'll issue notice today.
What I am saying, my lords, in so far as the police officers are concerned, my lords, please stay this notification, my lords, and all consequential proceedings, my lords. They are confirmed employees, my lords. They can't now, in the teeth of the High Court's finding, to say.
We have passed similar orders.
No, I understand, my lords, but those were orders pertaining to my lords, Assam Civil Services, which I will place, my lords, for item 64, 65, 66. But these police officers, my lords, form a class in itself.
It will have the same effect. We are saying that the orders shall not be given effect to.
But my lords, the fact is, my lords, not only given effect to in this case, my lords, High Court has held, I am confirmed. How can they treat me as a probationer, my lords?
We'll examine that, Mr. Chaudhary.
But all I'm saying is, my subject to meeting a lordship's approval, my lords. In so far as, my lords, item 63 is concerned, my lords, the police officers, my lords, the lordships will consider staying it and all consequential proceedings because it cannot be done, my lords. High Court has held, I am a confirmed employee. Others, my lords, your lordships may feel, my lords, okay, not be given effect to. But this is a brazen case, my lords.
We let the respondents respond first till the time they file any the counters.
Yes, my lords.
I think not giving effect to will serve your purpose.
But what I'm saying, my lords, is 141.3 is a standalone finding for Assam Police Service officer. That's why I'm pushing, my lords. I don't have post. They are being treated, held to be confirmed employees by the division bench of this court. And see, my lords, the order at page 66 says probationer. You cannot treat me as a probationer, my lords.
We'll pass the order. Hear us. Heard Mr. A. Chaudhary.
I'm praying for the same order at page 264 if your lordship takes, my lord.
Yes.
264.
B. Chaudhary. The counsel for the senior counsel strongly urges that a petitioner is a member of the Assam Police Service and of the 2015 batch. He joined the service on 15/9/2015 and under the rules completed his period of probation for 2 years on 15/9/2017. Stop. thereafter on the state discharged the order, discharged the petitioner on 27/7/2018. Stop. The writ petitioner, along with other similarly situated persons, approached his court by filing writ petitions which came to be dismissed, and subsequently intra-court appeals were filed. In the petitioner before this court had also filed an appeal before this court.
This is writ appeal number 147 of 2020. His writ appeal.
Number 147 of 2020. These bunches of writ appeals were disposed of by judgment and common judgment and order rendered by the division bench of this court by the judgment and order dated
20th June 2025. 20 June 2025.
2025, where the following directions were issued. Pursuant to the learned senior counsel submits that in terms of these directions, in terms of the findings arrived at by the division bench, the petitioner has to be treated as a confirmed employee and
has been treated, my lord, has been treated by the division bench as a confirmed employee.
And the power and the extension, the extension of the provision period issued by notification dated 2001/2018.
Yes, I'm grateful.
Stood set aside. Therefore,
and normally and held to be null and void.
Held to be null and void, not set aside, held to be null and void, and therefore, for all practical purposes, the petitioner has been held to be a permanent employee, regular employee, and not on provision. Stop. Under such circumstances, the state, in total contravention of the directions contained in para 140.
140, yes. First paragraph 138 also, if your lordship recall, my lord, where the findings are there.
Right.
Detailed findings, my lord, para 138.
0 of the judgment came to issue the impugned order dated 20.
A single judge, my lord?
No. The order of discharge that you are presently is
29/7/2025, page 66.
2025 came to be issued, whereby the petitioners was again discharged with effect from 27/7/2018.
By holding them to be probationers.
By considering
I'm grateful.
Contrary to the specific findings arrived at by the division bench. Being agreed, the present writ petition has been filed. Mr. D. Nath, the senior government advocate, appeals for the state. He submits that the directions contained in the judgment and order dated so and so have been complied with by the state, and in terms of the specific directions, the impugned order was issued, and therefore there is no infirmity in the discharge order dated 29th of June 2025, and therefore no interference at this stage is called for. Having heard the counsel for the parties and upon consideration of the issues raised in the petition, and since several other writ petitions have in the meantime been filed and notices have been issued, let notice be issued in this matter, making it returnable up to 4 weeks. Since Mr. Nath, senior government advocate, appears for all the respondents, notices are waived, extra copies be furnished within a period of 2 weeks from today. Meanwhile, till the next returnable date, the impugned notification dated 29th of July 2025 shall not be given effect to. We are passing the same orders, Mr.
And all consequential actions also, because this is a case where he's completely, he's a confirmed employee.
Not be given effect to, and as also all consequential actions there
are stayed. Will stay all consequential actions, because giving effect to all consequential actions may not rhyme otherwise.
In all other cases, and lordship has kept on 29/10. Let us file the affidavit in the matter.
Mr. D. Nath, learned senior government advocate, submits that other matters, some of the matters are fixed on 29/10. 2910. Is 2910 okay for you, Mr. Chaudhary?
Very well, my lords. We'll see. Let the reply come.
Matter be listed on 2910. Issue notice on the stay prayer also. We are directing not to give effect to the impugned notification as well as other consequential actions.
I'm grateful, my lords. My lords, 64
Yes.
is Assam. Lordships will have the chart again, my lords. Is Assam Taxation Service sees, my lords, 2015 batch.
This
I've
is
given.
is there any provision was completed on 26/8?
Yes, my lords. And my lord, they are not even claiming that her probation was extended. So she falls under 141(1).
Well, the other two matters are, the Lordship has in a case of ACS, Lordship has passed the order. These are similar.
Will issue notice in these two matters also? Keeping
Yes,
it.
my lord, your lordships may consider passing the, my lord, same order at page 264, my lords, to 279. That's a very detailed. Your lordships recorded all the contentions, my lords. Same contentions here also, man.
Heard counsel for the parties, issue notice.
264 to 279, your lordships.
Right.
Your lordships have given prima facie findings, my lords, recorded all contentions, including that of my learned friend.
Issue notice returnable on 29th. So what date will you fix?
2910.
2910. 2910. Till the next date fixed, impugned order dated.
27/7/25.
27/7/25 shall not be given effect. Issue notice on the interim prayer also.
Then third, my lords, is ACS, my lords.
Yes.
Pallavi Sharma Chaudhary.
Similar order.
Similar order.
All right.
And the fourth one also, my lord, is ACS.
Issue notice returnable on so-and-so 29th. Then till the next date fixed. Impugned order dated so-and-so shall not be given effect to which is 21/7/2025. As also the other matter, production list matter also.
Yes, my lord, 21/7, same date.
Production is ACS.
This is also ACS.
ACS, yes, my lord.
All right.
I'm very grateful, my lords.
Yes. Except 63, party matter data, the other orders are enclosed to the writ petition available. Yes.
Okay.
And my lord, 64 is Assam Taxation Service, as I told your lordships.
Yes, yes.
And 65 and the production list are ACS officers.
Yes. 63 is police, 60 tax, 65 in the production list are ACS.
Yes, I'm grateful.
Yes, we've got it.
Yeah.
Timing item 40.
Yes.
They are directed to produce the records.
What records were there?
Lordship, otherwise the corrigendum issue that has already been brought on record by way of an affidavit, your lordship. Now, what I have got is a selection process of 2014. Now, I have received one, the marks obtained in the viva conducted by the department, your lordship, wherein the petitioner's marks were reflected.
Who's for the private respondent?
S. Banik was there, your lordship.
And who's the petitioner here? Sumit Paul.
Sumit Paul.
Sumit Paul.
If
He
your lordship-
secured 42.
He secured 42, your lordship. The selected candidates were Hussein Ahmed, who secured 49. And on the second page, your lordship, serial number 20, Vivekananda Das, who belongs for the OBC and MOBC category, he secured 50.
No, petitioner belongs to which category? OBC?
Petitioner OBC, my lord. Respondent number 4 also, he cleared his written test as general category, but given appointment in the reserve category.
Which respondent for? What is his name?
Hussain Ahmed Majumdar.
Hussain Ahmed, Your Lordship.
That is
He
what
is
that
appointed
register
in
was directed to.
OBC.
Lordship, otherwise he belongs to the OBC category, MOBC category. But in fact, Your Lordship, the affidavit which I have filed, that is at page number 87.
Why were the records called for?
My lord, that register was directed to produce where he has put his, he has a general category. As I have submitted, my lord, while putting his signature by the petitioner as OBC candidate, he did not found his signature. So that is why they are directed to produce that register in the Viva Voce and they put their signature. It is specifically in our affidavit in reply we have filed said that, my lord, his signature was not there in the register, my lord, meant for the OBC candidates. That register was directed to produce. My lord.
By which order was it directed?
Yes, my lord, they were directed to produce, my lord. On last occasion also, on last 2-3 occasions, they took time to produce that record, my lord.
Even I put time on my health issue.
Even otherwise also.
Well, that is not available, Lordship. As on that's 2014 records.
But this is produced.
No, my lord, he is now saying that is not available.
Lordship, my learned friend is asking for a register, Your Lordship.
What register?
My lord, OBC, sorry, my lord, no.
Wherein the candidates used to put their signature whether they belongs to the general category or under the reserve category.
Why is that?
During the Viva Voce test, my lord, two separate registers were maintained. Two separate registers were maintained, my lord, one for the OBC, one for the general category. As in my reply, my lord, I have specifically said, my lord, while putting his signature by the petitioner, I did not found the signature of the respondent number 4.
It is the
He was shown
contention of
to
the
have cleared.
petitioner, Your Lordship.
He has shown to have cleared the written test as a general category candidate, but given appointment as reserve category candidate.
And you appeared as an OBC.
OBC. I'm an
How
OBC
many
candidate.
vacancies are there?
Lordship.
My lord?
Vacancies.
For general and OBC, how many vacancies?
One post.
Two posts, my lord, one general, one OBC.
Yes.
And how many persons have you appointed?
Only the Hussain Ahmed, Your Lordship, respondent number 4.
But you have appointed, what about the other gentleman at serial number 20?
Vivekananda Das, Your Lordship.
No. He is also shown to be selected.
Yes, Your Lordship.
So you have appointed 2 MOBC, OBC.
2 MOBC, Lordship.
Huh?
There, that's the point.
And who is respondent 5 and 6?
5
and 6. There are 2 other candidates, my lord. Actually, their names were not reflected in the written test. The written result of the written test when it was published, my lord, their names were not reflected. But subsequently, they are appointed.
No, but their names do not appear in the Viva. Does it appear in the
Lord-
Viva list? Does
Their
not
name,
appear?
their names doesn't appear, Lordship.
Then how are they appointed?
No, they belongs to the general category, Your Lordship.
No, their names nowhere appear, man.
And in fact, on the last occasion, Mr. Banik, he said he's representing the respondent number 4 units. The other twos are,
All right, you tell us, there are two vacancies, one for general, one for OBC.
Lordship.
In the Viva OC, you have shown 2 persons selected, both are OBC.
Lordship may grant me,
We have been granting you time for the
Lordship,
last 10 years.
I'll get the instruction over phone right now, Your Lordship.
We have, no, don't get instruction. You call that officer with all the records. We'll get the instructions from him. 10 years matter is pending for instructions.
Lordship, otherwise that register is, as per my instruction, it's not available, Your Lordship.
If it is not available, we'll interfere with the appointments. List on 16th. Enabling Mr. G. Bordoloy, Standing Council Registrar, Cooperative Society, Registrar of Cooperative, Department of Cooperation. Right. To produce all relevant records to in connection with the selection, which is being selection of the private respondents, qua the writ petitioner, which is presently challenged in the present proceedings. List on so and so date. 16. Please take back the original.
Typing agent 43.
Yes. Registers.
Well, registers we have got.
What is there? Show us.
So far as the attendance register is concerned, my lord, that is not traceable because there was shifting and all, but my lord, the salary register we have got. Her name appears, my lord, till February 2016.
That is her case that she has been coming.
No, whoever is working, my lord, they are being paid, my lord. Same persons are there, my lord, here. Her signature and receiving of salary is
How
there.
do you come to the conclusion which persons are working? How many persons are working there?
Well, all casual, my lord, or daily wages, their names are here, my lord. Her name also appears till, my lord, February 2016, till the time she was working.
We are not disbelieving you. We are trying to understand.
Yes.
That this is in the what medical college.
Medical college.
They are working as what?
Daily
help desk.
wager, my lord.
Huh?
Daily wager.
Daily wages?
Yes.
So these daily wages will
They
have
will have a, my lord, this particular, so whatever salary, my lord, after calculating their number of days they have worked.
Before you give them the salary, you must maintain a record to show how many days they have attended.
It's there, my lord.
Where?
In this register, my lord.
So this register is with us. This register is after you have released the salary, etc. Or
My
you,
lord,
with regard to
if, my
salary.
lord, she has worked, only then, my lord, salary will be released.
That's right.
Either way, my lord, from
To ensure that a person comes and works, either there has to be biometrics or an attendance register.
at that point of time, 16, there was no biometric.
All right, then some register must have been there. Otherwise, it is
Even then, my lord, it is discernible, my lord, because without, my lord, her attendance, my lord, we will not be releasing a salary.
That
Till
is her
March,
case.
it is there, my lord.
No, it is her. That is the case that she is trying to urge, that in spite of coming and trying to attend duties, she has not been allowed to sign.
No, there's not an allegation. My lord. She is contending that, my lord, she is working.
Salary not released.
My lord, since the date of her joining till date, without any break, she is continuing. That is her contention, my lord.
That's right.
Whereas, my lord, she was transferred to another, my lord, establishment on 9/2/2017. In fact, we have issued show cause, my lord. Lordship will see, my lord, we have issued show cause notice for her, my lord, unauthorized absence, page, my lord, 41. January 2016, with effect from January 2016 to till date. This was issued on 11/7/2016. Thereafter, she was transferred. She is nowhere there, my lord.
See, earlier there have been several orders for the attendance register.
Yes.
And so many opportunities have been given. Today you come, a cost has been imposed, you pay the cost, and now you tell us that the attendance register is not
That's why,
present.
my lord, because of this, my lord, shifting and all, my lord.
You file an affidavit then. You get the officer to file an affidavit that attendance register is not available.
It is misplaced, my lord. But
Whatever.
otherwise, we are not trying to, my lord, just to, my lord,
My lord,
deprive the petitioner from the salary and all. It's not that, my lord, for that reason, we are not placing. The
We are
very,
not even indicating that.
well, that's why I'm saying, my lord, this salary register is very, my lord, clear. Till the date, my lord, we are claiming is there, my lord. And, my lord, from 2018, my lord, the job that she was doing, my lord, under the, my lord, Hospital Management Society as a daily wage earner,
no.
that part has been now discontinued. It has been outsourced.
My lord,
We have stated in an affidavit, my lord.
my lord, regarding
1/4/2018. And her statement is that, my lord, till the filing of the writ petition, she is continuing. Whereas she is unauthorizedly absent, my lord. Then daily wage earner, my lord, if she doesn't come, where is her right to at least, my lord, claim for that?
That is what we want to understand. How is the management trying to discern, trying to find out which worker is available, which worker is not, unless there is some kind of an attendance register. How will you find out which worker has?
Yes, my lord, we have got one registered. It is from November 2019 to December 2021. At least.
That is already produced before the court earlier.
No, Lordship will see, my lord, from 19 at least. Again, my lord, her absence, it is mentioned her, my lord, presence to be, my lord, she is not, she is absent.
March 2016.
Her attendance is absent, my lord. Even if her name is not there, my lord, because she is not appearing.
This attendance register is for which period?
From, my lord, November 19 to December 21. So the writ petition was filed on 2020.
December 21.
Yes.
Her name is not there.
Not there. Amongst the employees.
my lord,
Otherwise.
what happened, my lord, page 42, my learned friend has pointed out, my lord. My lord, hearing this, my lord, I am transferred in MR department. My lord, in fact, my lord, they have stated in their affidavit, my lord, this particular transfer order has not been communicated to me. Since, my lord, not communicated, I am not able to join there. And, my lord, in my affidavit, clearly I have stated, my lord, I am attending in the hospital, my lord. My signature has not been allowed. I am not allowed to put my
That's a
signature.
wrong statement.
How do you prove that? How does this court accept the statement that you are not allowed to?
Now, my lord, in earlier occasion also, your lordship
You
kindly
filed the
see.
writ petition in 22.
My lord, earlier occasion, your lordship kindly see.
You filed the writ petition in 2022.
22, my lord.
And since when do you have the registrar? Register is from?
November 2019.
November
2023.
From November 19, there is no signature. And you filed the writ petition in 2022, asking for area salary.
My lord, I am asking from, my lord, I am asking for salary for the period, my lord, March
From March 16 to October 20.
March 2016, from March 2016.
Correct. March 2016 you are asking.
My lord.
But from the register which is available from October 2019, their records show that you have not signed.
My lord, as per my information, I put my sign, my lord.
I do not know.
And in fact, my lord, the petitioner has resorted to, my lord, placing, my lord, some manipulated document.
No, my lord, in this regard, I have.
Page 49, or you will see, my lord, some attendance.
One by one, my lord, kindly.
Our, my lord, register, whatever was there, we have placed it, my lord, in the reply.
No, my lord.
But it doesn't tell you.
No, my
We have
lord.
manufactured
I
this,
have,
my lord.
I have some attendance register I have annexed in my writ petition. They have not make any question, my lord. My lord, in my additional affidavit, my lord, I have some, my lord, since, my lord, I have not allowed to put my signature after filing of this writ petition, my lord. My lord, I am here and there. Since, my lord, I am transferred to another department, they have stated, no, she is not find out, my lord. That's why, my lord, I could not join, my lord. Now, my lord, in earlier occasion, my lord, department was directed to bring my learned friend was directed to bring instruction.
Mr. Gogoi, you show the council the register.
My lord, in the
You have a look into the register and tell us whether the signatures are there or not.
Sure.
My lord, as per my instruction, my lord, I put my signature.
Why don't you see the register? It
That
is
my
there
lord,
in court. We are
I-
permitting you to examine it with the consent of the counsel for the respondent.
My lord, my humble submission, my lord. My lord, till today, my lord, I am not terminated. My lord, I am serving here, my lord, in the department, my lord, since 2009, my lord. My lord, 9 years already passed. Now, my lord, in 2016, dispute has come. I am not, my lord, till today, I am not, my lord, terminated. Since, my lord, my service has been transferred to MR department, I may be allowed to join there, my lord. My lord, in the
Who is
mean,
stopping you?
my lord, my humble submission, my lord. Since
Who is stopping you? Go and join.
my lord, they are not allowing, my lord. They are saying, my lord, in their affidavit, I am not found out, my lord. My lord, since, my lord, after filing this affidavit, my lord, I have come to know that I am transferred. My lord, they may be allowed, my lord, to join there.
Still, if you are not aware where you are transferred. You are not aware where you are working.
My lord, they have stated,
All right, when was the affidavit filed?
My lord, affidavit filed in 2000, my lord, affidavit, their affidavit has been filed, my lord, on, my lord, on 17/6/2022, my lord.
22.
My lord.
From 22, you are aware that you are posted in some department, and in 25, you are asking that direction be issued to permit you to join.
That's why, my lord.
Who's stopping you from joining since 22? Did you go and verify it?
My lord, they are not allowing, my lord. My humble submission, my lord.
You go and file
lord,
an
I am,
FIR
my lord,
to
on
the
daily
nearest
wager,
police
my lord.
station, ask for police protection.
My lord, I am daily wager, my lord. My lord,
Mr. Counsel, don't make a mountain out of a mole. 22, you are aware that you have been transferred.
My lord.
3 years you wait. Don't go and join. Now you want a direction from the court that you should be permitted to join.
My lord, your lordship kindly see, my lord, in fact, my lord, after receiving this affidavit, my lord, I went there, my lord. They are not allowing, my lord. My humble submission before you.
Where have you stated all that? How have you gone? How did you go? Did you file an application to join?
My lord, your lordship kindly see my affidavit, my lord. My lord, your lordship affidavit, your lordship page.
Which affidavit filed when?
My lord, page, my lord, running page, my lord, 47, my lord. 47, my lord. Paragraph 6, my lord. May I read, my lord? My lord, I am serving only daily wager, my lord. My lord, I am very much there, my lord. They have stated in their affidavit, I am not found out. My lord, how can I, my lord, without receiving the transfer order, how can I join, my lord? Now I am pursuing, my lord. They are not allowing, my lord.
Where is the statement source?
My lord, paragraph 6, my lord, 47, running page 47, my lord. Paragraph 6, my lord. May I read, my lord?
Yes, please read.
That the deponent petitioner begs to state that the instant writ petition has been filed on so and so and so. And the respondent number 4, after receiving the notice from this honorable court, the co-employee, namely so and so, my lord, initially we are appointed in similar time, my lord. Placed in the other unit of the hospital, but the deponent petitioner has been discharging their duty along with emergency unit. May I help you putting her signature on the daily attendance register? And she is now collected photocopy of this attendance register from the January 2000, May 2022. Therefore, the deponent actually begs to state that he would come to the interference of this calling this original attendant. Now, my lord, your lordship kindly see. My lord, after receiving the notice from this honorable court, other, my lord, employee, my lord, they have been, my lord, transferred. I am alone in the, my lord, department, my lord. My lord, my humble submission, my lord. My lord, there is admittedly, my lord, in their affidavit, they have, my lord, there is some absence on my part, my lord. My lord, absent period may not be paid, my lord. Absent period may not be paid, my lord. My lord, in the meantime, my lord, my service has not been, my lord, terminated.
You have not gone and joined. You are supposed to show us that you had gone and joined in your new place of posting, or at least a averment that you wanted to join, but you were prevented from joining or not permitted to join. Where are these statements? Heard, Learned Counsel, for-
My
we
lord,
are,
Your Lordship,
we
Your
are
Lordship-
closing your petition.
My lord, Your Lordship kindly, my lord, allow me to join there, my lord, at least, my lord.
Have we stopped you?
That may be pointed out, my lord.
What?
Otherwise, my lord, I am.
We
my
are
lord-
not saying a word any more than is necessary while dismissing your petition.
My lord, Your Lordship, I leave you before Your Lordship. My lord, my service is very small service, my lord. I can say, I cannot say, my lord, anything before authority.
See, sympathy and empathy don't make good law.
My lord, I understand.
You were working, you were claiming area salary from 2019. Since 2016, 2019 register, which we have permitted you to see, which you don't want to see, does not show your name.
My lord, I may be allowed
There is
to
no
very-
explanation, number one. Number two, 22, you come to be aware that you were transferred to some other department. 25, you want a direction from the court that you should be allowed to go and join. Where is the explanation that you had gone and joined and you were refused to be permitted to be to join? Where is that statement?
My lord, little time may be given, my lord. I will verify the register, my lord. A little time after-
We are closing it. You have all the time thereafter. This is not fair to the court. We had given you sufficient liberty. You are unable to answer the question?
My lord, it may be taken other day, my lord. I will take instruction, my lord, more instruction. Otherwise, my lord, entire, my lord, we will go, my lord. Other day may be taken.
18th.
Well-
And no adjournments on 18th. List on 18th, only prayer made by the council.
My lord, I may be allowed to verify the register, my lord.
We have already permitted. He has been kind enough to permit you. Sir, don't seek permission to take the register home. That cannot be allowed.
Obliged,
18th of September. Yes,
Lordship, we're taking some accommodation for the day only, your lordships. As thus have some difficulty today, your lordships.
you are for the SIDC,
Yes.
ASIDC.
Yes, lordships.
What is your name?
S.A. Borboya on behalf of Mr. S. Das, lordships. Is a personal difficulty today, your lordship. For the
All right.
day,
I showed that maybe fix that, lordship.
The matter stands deferred on the prayer made by the council for the ASIDC that the standing council is not available to address the court on this matter. And the matter is, the prayer is made to have the matter listed on some other date. List again. Twenty-seventh October.
deeply of lordship.
Along with this. Right, we are yes.
All the four petitions have been filed by four petitioner. They are the employee of Assam Fishery Development Corporation, and they have retired from service after taking the superannuation. So the authority has not released the gratuity. The petitioner, after repeated reminders, gratuity amount has been deposited in Life Insurance Corporation of India, and Life Insurance Corporation of India has released the amount to the Assam Fishery Development Corporation, but they have not released the amount till date. Lordship is aware, as per Gratuity Act, within 30 days from the date of retirement, it should be released. And Gratuity Act, Lordship is aware, the gratuity is the overriding effect of all acts.
Yes.
That should be released, but till date they have not released. Ultimately, they have filed an affidavit stating that there is a vigilance case in respect of some employees according to FIR filed by the managing director.
Are you allowed pension? No pension.
We are getting pension, nominal pension from Provident Fund. That is your own contribution. We are getting some 3,000 and odd as a provisional pension. 3,000, 3,948.
So your gratuity is not released.
Released.
What do you say?
May I please your lordship, my senior is in the midst of argument in other court.
But this
It's
case has
coming.
been adjourned, let's say, time and again.
We'll keep it on 15th. 15th, Monday.
Lordship on not hearing an motion day, Tuesday, Lordship.
Tuesdays, then 18th. Oh, he comes here. Yes, why have you not released the provident fund?
Sorry.
Sorry, gratuity.
Yes. Gratuity part lordship, there is we are in a fixed lordship, the department. Gratuity part is also there because they have, if the allegation is that they have is dishonest to the organization, honest lordship, but that part lordship.
Can you deduct that?
Lordship, we are not deducting lordship, we are just holding it up. Lordship, we got a, actually the fact is that we are in a fixed lordship. It is apparent from the this order also that we got a, as per PML, we got a letter lordship. So in PML lordship, there is a provision section 23 lordship that even there is a predicate in predicate offense, though their name is not there. In that case also they can rely on that part lordship. So lordship, I have filed an affidavit also on that effect lordship, in that effect lordship. So I will rely on that part only that lordship. I leave it to lordship. So I will, but I have to rely on this affidavit lordship.
Affidavit in opposition.
Yes, lordship.
Yes.
What they have been projected that one vigilance case was pending against some officer of the corporation. That is why our amount has been withheld. Though they have certified. Lordship will kindly see, then they have arguing the case. I will point out this case now. Lordship kindly see page 23 of the repetition.
Yes.
That is the release letter after attaining the superannuation. Internal auditor of the corporation, Sri Ranjan Kumar Das, after attaining the of 60 years, will be superannuated on 31/3/2023 as per government rules. All files and documents related to accounts under his custody may be handed over to the assistant account officer, Iman. As such, he will be released with effect from 31/3/2023. Now, Lordship will find I have handed over the document, page 25. All the documents has been handed over, page 25. And it has been taken over by the person who has been directed.
Yes, lordship, that's not.
Lordship, thereafter, page 26. It is a certificate by the managing director himself. This is to certify that Ranjan Kumar Das, internal auditor, who was retired on 31/3/2023, was released from his duties upon retirement. He was a sincere officer during his tenure of service period. He is good moral character. This is certificate given to the managing director. Now, let's see the provident fund pension, page 27. Pension amount is 3948. Page 27 also. Now, leave encasement and other things, page 28. Everything has been released.
Yes, lordship. There was an order, lordship. We are held up by the initiation of enforcement director, lordship. There is a provision, lordship.
Now,
if they are involved, lordship, that part, lordship may pray one thing, lordship. Let enforcement director also may be a party in this case, lordship. Let them say.
We have not received any notice from the, let's say, the ED. Now they are saying that ED will listen to this. We have no case against
Where is the communication from the ED?
Nothing.
Communication from the ED, I think. I will place the record.
Can we say page 30?
I will place the record, lordship. Yes.
Lordship, can we say page 30?
Day after tomorrow is a holiday. Monday also, lordship can fix.
Can we say page 30, lordship? The case registered on the basis of this complaint. Joint Secretary Government of Assam to the Managing Director. Kindly see that.
Yes, ma'am.
Page 30. With reference to the above, I am directed to inform you that the matter relating to illegal transfer of fund of the corporation in the name of different official, including ex-chairman, vice-chairman, as well as contractors, suppliers, has been examined by Government in Fishery Department by Senior Most Secretary of the department based on detailed report submitted by you. White later under reference. It appears from your report that despite of objection, views against such advances by the accounts branch of the corporation, the sanctioning authority granted such advance, ignoring the advice of the account section. which is a serious financial irregularities. We are from the accounts branch. Government is of the view that such authorized transfer of fund is illegal and exceeding the financial norms of the procedure. You are therefore requested to take legal and administrative action against the official who were involved in such illegal transfer of fund and lodging of affair immediately. And on this basis, the affair has been filed. Now I will take the affair. Kindly see the affair. Page 64 of the running page. Page 64 of the running page, the affair, on the basis of which the affair has been filed. We are working in the account branch. We have given serious objection regarding release of fund. Page 64. Running page 64 of our actually Rita. Lordship got it?
Yes.
This is the affair to the officer in charge comes to of police vigilance and anti-corruption. This is to inform you that team of Director of Finance and Inspection, Government of Assam had indicated financial irregularities and misappropriation of AFDC's fund after verification of the official record. AFDC, after receiving the report, undersigned conducted an internal inquiry of the said facts. The Director of Finance Inspection and thereafter the following AFDC Limited officials are found to be involved in following works during relevant period from Iman to Iman. Rupees Iman and Iman. The persons are, name of the officials are Naren Kumar Bosumatari, Padma Kumar Hajorika, Jyotish Soikia, Birinsi Odhikari, and Soruddin Ahmed Ehsan Engineer. And second one is, that is one of the Managing Director Corporation, Anuradha Adhikari, Padma Kanto Hajorika, Robindranath Dheka, and Bhagirath Das Project Officer. And next is Naren Theka, Aniruddin Soike, and these are the persons. We are nowhere. Till date, ED has not issued against us any notice. Lordship is aware regarding provision of information. We have made a compilation regarding our case, Lordship, kindly see.
What a copy. Let me give a.
Lordship, kindly see we have made a compilation regarding the.
You give him a copy also.
Lordship, this is compilation regarding the act. This is Gratuity Act, Lordship. We made the compilation for court benefit.
That we already have, all right. Thank you. Yes.
Lordship, payment of gratuity.
But you have judgments also?
Lordship, judgment, Lordship, I will give the copy, Lordship.
You give him the copy, we'll take it up next week.
What is here? Minor thing, Lordship. Regarding their involvement, Lordship, page number 30, Lordship, of this petition, kindly is 2252, Lordship.
30.
30, yes, Lordship.
Yes.
Lordship, this is a communication.
By the government.
There is a, Lordship, this is the view of, I'm giving the suppliers huge against such advances by account branch of the corporation. That's the crux of the case, Lordship. They were aware of the fact at the roots of the case, when the funds were disbursed around around several crores of rupees. I don't know the amount, Lordship. Amount is high, Lordship. Here the amount is, I think, 11 crore. It is higher. After investigation, it has become high. So if they know in the roots of the case, they should have immediately informed to the concerned authority.
We are objecting that.
They cannot object. Let me complete. Objection in CRPC, Lordship. When the commission of a criminal offence is known to somebody, they should have informed to anybody, Lordship, to the official concerned, Lordship. They have not informed.
Who are they? Their accounts, internal.
Yes, they are the signing authority in the SEC, Lordship.
Sanctioning authority.
In the signing authority in the SECs.
We cannot sign SEC.
No,
SEC will be signed by the managing director.
Check is signed by the accounts. Lordship, my friend.
No.
Check is signed by the accounts.
Before the check is signed,
Lordship,
there has to be somebody to sanction this amount. Who is the sanctioning authority?
both of them, Lordship, it's a very big scam, Lordship. This scam, I will, in Lordship, fix a date for hearing. I will let it know, Lordship, everything, Lordship, with the records, Lordship. It's a sanctioning authority, even MD has been dismissed, Lordship, has been given for compulsory retirement, Lordship. Just punishment has been given to the MD, Lordship. MD is the CS officer is no more in the job, in the service, Lordship. Anuradha Adhikari Sharma is no more.
What is their job? That is what we want to know. What are they supposed to do?
They are supposed to verify, Lordship. I will let you know with the records also.
Because the letter you are referring to,
Lordship,
says that despite objections raised by the accounts branch.
Yes, Lordship, this is
sanction.
That this is being said by the Joint Secretary of the Fishery Department, not AFDC, Lordship. Fishery Department has advised us, Lordship. We are AFDC, Lordship. It is the letter which is in fact insignificant in some sort. They are, but we are AFDC, Lordship. Our fund is not government fund, Lordship. We are revenue we have collected from by leasing fees to the property, Lordship. That we are nothing to do with the government. They have advised us in this letter. This letter, though it seems that they are the Joint Secretary letter is in their favor, but in other way, if we see that while knowing the commission of an offense, criminal offense, they should have informed at the roots of the case. Then this scam would not have been happened, Lordship. There's crores of rupees is being siphoned off from our corporation. Around 11 to 20 crore is being siphoned off, Lordship. So let it be another. I will produce all the documents and
My submission will actually, what he is submitting, that is a laughing stock, Lordship. Because we are the official of the account branch, we have giving objection. Thereafter, they have released the amount in favor of some official and its contractor. But this report has been given by the managing director himself, the present managing director himself giving the report. Lordship, kindly see again. With reference to the above, I am directed to inform that the matter regarding illegal transfer of fund of the corporation in the name of different official, including ex-chairman, vice-chairman, as well as contractor supplier, has been examined by the government in Fishery Department.
We'll keep it for admission hearing.
And detailed report has been submitted by the MD.
Please take it. Tell us when you, after vacations?
No, Lordship, because Lordship, we are not getting anything, we are suffering.
For the last 2 years, Lordship, it's been filed after 2 years of the cause of action, Lordship. Lordship, let it be after vacation, Lordship, not 15 and 16
Lordship,
and
this
17.
order has been communicated to us on Lordship, Lordship will find at page 35. This has been communicated on 19/3/2025. Immediately, we have filed receipt petition.
But they were not getting salary for the last 2 years, Lordship.
Not salary. This
No,
is
sir.
regarding gratuity.
Gratuity, Lordship, yes. Gratuity or everything. After 18, Lordship, any day, Lordship. 15, 16.
Then let us have it after vacations. Because last week of September to, we don't think we'll be able to do any
It's a
hearing.
motion day.
If possible, Lordship. Because Lordship, we are not getting any pension.
We can, the earliest we can give you is 16th or 18th. You take whatever. date.
18, Lordship.
Lordship, get in with 19, Lordship. I have several matters fixed on 19, Lordship.
You make an attempt.
Lordship.
18th
Lordship.
is agreed to by the council ruling parties.
And similar situation, Lordship, in similar situation, this honorable court and pass an order in case when employee of Lordship, the Gaon Panchayat case, Lordship has directed that
produce, sir.
Produce that. Give it a judgment. Here the case is pending against him. Report is against him. Lordship directed that gratuity cannot be withheld.
We will examine your matter on 18th.
18.
Apply this.
District and-
Yes, it's a bit complicated by entering for enforcement director, Lordship. That is the issue. Highly obliged, Lordship.
Item 62.
Oh. May I please, Lordship? My Lord, petitioner before your Lordship was the in-charge superintendent of municipal office, my Lord. He was placed under suspension by page, my Lord. 37, my Lord, 18/1/2025. At page 37.
Yes.
That too also, my Lord, I'll take it very small.
What is the stage of the inquiry?
And but that I'm coming, my Lord. That first, my Lord, I have been asked page 35. So cause.
Yes, you
For
replied.
particular reason, my Lord.
You replied.
I replied. Then, my Lord, I replied by page 36, my Lord, there is no authority, I cannot issue any permit. Thereafter, my Lord, page 37, for another reason, my Lord, now it is altogether different, my Lord. I was placed under suspension and I have given a show cause notice on 10/3/25 page 38, my Lord. And they have, my lord, given, and now the question comes, my lord. Lordship kindly take up at page additional affidavit file 79, my lord, page 79. Additional affidavit, my lord. Lordship kindly have a look, page 79. There, my lord, it was issued on 25/25 until further order. Para 6 of that page 79, man.
79.
9. This is the additional affidavit chronologically. Lordship will see page 79.
Yes.
Lordship will see in the last 6 paragraph, in view of the above, so and so pending drawing of the departmental proceeding of the so and so, Khagyan Chandra Superintendent number so and so extended until further order. Only that much, my lord, until further order.
What is the stage of the inquiry?
My lord, that I'm coming 1 minute, my lord. I'll just come, my lord. Thereafter, my lord, coordinate bench said, my lord, page para 29, my lord. Lordship, I'll take up directly to page 95. Para 29, my lord. Small paragraph, may I read, my lord? That the law laid down by the Supreme Court would therefore be mandate the suspension order being issued. Concurrency of the same would not extend 3 months if within the period the memorandum of charge sheet is not served to the delinquent officer employed. The second part of the law mandates that if the memorandum of the charge sheet is served, a reason order must be passed for extension of the suspension. Second part of the law declared the Honorable Supreme Court cannot be read as a isolation, has to be read as a conjunction with the first part. Accordingly, it is to be understood that concurrency of the order suspension, while not being permissible to be extended beyond 3 months from the date of its issue, if the memorandum of charge sheet not served on default officer employed, if the memorandum of charge sheet is so issued within 3 months, the same shall essentially be accompanied with the reason order. But here, my lord, page 79, Lordship has seen there is no reason order, my lord. And that also issued, my lord, suspension was 18 January and that extension was issued on 20 May, my lord, more than 3 months. So cause issued, my lord, though accepting, my lord, there is a 2-part, my lord, Ajay Chaudhary. Reason order, my lord, there is no reason order. In earlier, so and so the reason order extending suspension of delinquent non-service of the delinquent order, delinquent within the memorandum of the charges is not so sub that the order of the suspension ceased to operate, delinquent officer, so and so. But here, my lord, what happened? During pendency of the writ petition, I got retired on 31st May 25. I got retirement.
This is rendered in the facts of that case. I don't know. But the paragraph of penultimate paragraphs of Ajay Chaudhary doesn't say so.
My lord, there is a
You have to.
Even in this Doctor case, Lordship, suspension was not, he was not reinstated. Ultimately, he was kept under suspension, Lordship. Court has not passed any order directing him to reinstate.
My lord, I am not
3 months suspension, review within 3 months.
My lord.
Or
second part is there, my lord. Extension, show cause, and accompanied by the reason order.
Reason order of?
Reason order, my lord, why they want further order. Extension of.
This is not what is stated in Ajay Chaudhary.
Ajay Chaudhary said so,
No,
my
let
lord,
us
as
see.
per the judgment.
Let us see the judgment if you have.
It may be reproduced in that judgment number. Ajay Chaudhary relevant portion is reproduced, my lord.
Page number?
Para 23 onwards, my lord. So is the present proceeding came up for consideration of the presenter that the coordinate Relying upon the laid on the Supreme Court.
So the
order-
paragraphs are not extracted.
No, I mean-
100 is extracted.
One should be determination of the frame person that the relevant at the stage of the understood the para 11 of the Supreme Court. Ajay Kumar Chaudhary, page 91, my lord, 34, it been projected, my lord, para 34, it is relevant at the stage to understand the paragraph number 11 and 12 of the Supreme Court in case of Ajay Chaudhary Supra has detailed out the.
Do you have the judgment with you or not?
No, my lord, not
You
right
don't
now,
have.
I do.
Then you bring it and we'll examine it.
My lord, day after tomorrow, my lord.
Day after tomorrow is not possible, next week. Pick a date next week,
Possible date may be fixed, my lord.
17th.
My lord. I'll bring about it.
Mr. J.I. Borboya for the petitioner, Mr. P. Nayak for petitioner lady for the state. Mr. Borboya submits that he would like to refer to the judgment of Ajay Chaudhary. Therefore, submits that the matter be listed on some other date. Is agreed to list on 17th of September.
Monday.
Or you want it after the vacations?
No, my lord, I'm not getting any.
All right.
I think 67.
Well, for appointment of arbitrator, my lord. Your losses will see, my lord, the clause is, my lord, at page 30.
Page?
30. 30. Okay, 17. Clause. In case of any dispute.
Yes.
Now, my lord, what happened, my lord, there are some correspondences, my lord, notices were issued. And
What?
we issued a reply to my lord saying that we should file a suit. They replied where they have said that go to arbitration, not suit. That is at page, reply 93 and 94. Now we file a suit, my lord. In the suit, my lord, we have taken a plea, my lord, in the written statement that it is covered by arbitration clause. Accordingly, my lord, we do the suit, my lord. Now, my lord.
Where is the notice under 21?
Hello?
21 notice?
Yes, that is issued, my lord. That is there. My lord, page 109. Page 109. And 118, my lord, report is there, it is delivered. Now they have filed a affidavit before yesterday, my lord, denying some of the allegations made by us, my lord.
This is 21 notice.
Yes. January itself is super.
Then? Yes, any objections here?
Yes, my lord, in fact, what happened, there is an allegation of fraud by them against us. The criminal proceeding is continuing. Therefore, my lord may appreciate, once there is a fraud has been alleged, then whether it is arbitrable on that issue is there. Number one. Number two, lordship will find this paragraph 8, para 10 and 12 of their petition, my lord. They themselves said that we have committed fraud. There was formation of a company by misrepresentation, diversion of funds, forging documents, all allegations are there. And consequently, they have filed one complaint case before the judicial magistrate at Dibrugarh, where the cognizance was taken under section 468.
No, but you agree, you have signed in the arbitration agreement.
That's fine, my lord. That is there. But once there is a question of allegation of fraud is there, so therefore that would be the deciding factor whether it can be referred or not.
When the fraud is alleged, There has to be a conclusive finding by a court of criminal, competent court of criminal jurisdiction as to whether these allegations.
Under the same subject matter, they also referred in the arbitration also. That cannot be two parallel proceedings.
Arbitrator is not going to come to a conclusion whether forgery is there or not.
No, that-
Arbitration is going to arbitrate and decide whether the claims vis-a-vis the parties.
That is their dispute, my lord.
Ah.
That is their dispute. They have said by forming a company that we are diverted that's their allegation in the complaint case. Either they have to come up for a arbitration withdrawing everything. Because there is a judgment of the Supreme Court, Lordship is aware that once the allegation is fraud is there, the High Court also says that the Section 11 could not be entertained. Now, whether that is a serious fraud or the simple fraud.
Which judgment you are referring to?
My lord. So just
Let us do what says, my lord, these are.
and the
simple
recent.
fraud, my lord, nothing is there.
No,
They have diverted the-
no, how they must came up, they have not placed before this honorable court the complaint case. They are simply referring the paragraph 10, man. Wait, reference 2012, 5 GLR 60807.
Yes.
807. Paragraph 10. And Supreme Court judgment I will place of 2021.
Yes, please.
May I read, my lord? Moreover, this is a case where serious allegation of fraud, manipulation, and misappropriation is made, similar to our case, against the party who demands adjudication of the dispute through an arbitration proceeding. But considering the seriousness of the criminal charges alleged against the petitioner, by the respondent and the pendency of the criminal case against the petitioner husband, I feel that this may not be an appropriate case for adjudication by an arbitrator. When serious allegation of fraud and malpractice are alleged against the petitioner in respect functioning in the partnership firm, and a civil case is pending, appreciation of evidence on normal court will be a better way of dealing with the matter. And also the 2021 judgment, my lord. First, I referred to a judgment of 2016, my lord. It will be
Yes.
16. 16. 16. Lordship, kindly have a look at paragraph 14. It is, sir, 1610 SSC 386. Here there are some categories, my lord, where.
Swami has been explained, I think, later.
Yes. That's 21 judgment. A vital post studios that says that whether it's a serious or simple fraud. Now, my only question, my worries is, my lord, that they should say, because they have not placed before this lordship the complaint case, that they proceeded. They may come up with a clean end for the arbitration, my lord. They have filed a criminal case, then the civil suit. The one suit is still pending, money suit. The title suit reportedly withdrawn, but that also document not placed before this honorable court.
No title suit in view of Section 8, perhaps.
No. They are saying that they first filed their criminal case against us. Second, they have filed title suit and money suit simultaneously. In title suit, they have challenged some lease deed, etc., and also alleging fraud. Now, in that title suit, they have filed an application. Since there is an arbitration clause, so we withdraw. But the money suit is still pending. And that claim is also the claim of the Section 21 notice.
Money suit is pending.
No, money suit, my lord, we have filed a petition for withdrawal, but that has not been, that is not there.
No,
That is
so
letter. We have
it's a
filed.
premature petition.
They have received it. That's what we-
That I have
We
not
have received
disputed,
that.
but that's still pending.
No. Pendency means the judge was not there in the meantime, my lord, that, the last date. That is why, my lord.
And the criminal case may be withdrawn, my lord.
This was the later judgment.
Later judgment, my lord. 21. 21, 4 SSC 713. Paragraph 34 to 35, my lord. 21, 4 SSC 713. And Vidyadhuri case also, Lordship is aware that that also refer. 35 kindly have looked. 35. May I read?
Yes.
After this judgment, it is clear the serious allegation of fraud arises only if either of the two tests laid down are satisfied and not otherwise. The first test is satisfied only when it can be said that the arbitration clause or agreement itself cannot be said to be exist in clear case in which the court finds that the party against whom breach of alleged cannot be said to have been entered into an agreement relating to arbitration at all. The second test can be said to have been made in case in which the allegation are made against the state or its instrument to arbitrary, fraudulent or malified conduct, thus necessitating the hearing of the case by a reed court such and such. Although at this stage it is necessary to deal with the broad statement of the law, such and such, to cases involve serious and specific allegation of fraud, fabrication of documents, forgery, impersonation, coercion, etc. This must now be understood in the sense laid down in ISME case that's I referred to before your lordship. When it comes in para such and such, important to remember the certain facts of the such and such, my lord. And in ISME case, my lord, in 2016, the criminal case is pending, there is not arbitration. And the early is for 68 for 71, my lord. And that the categorization, matrimonial case, this patent law, the criminal case, all are the excluded. Because in ISME case in para 14, there's the 6 categorization.
Swami was explained. Is it explained here in this judgment or was explained in some other judgment?
My lord, I am not placing that in Vidya Valley. The only question is what is the serious part of the simple fraud. Now they allege against us a serious fraud we have committed, my lord. And this judgment says the ISME case is to be followed. In paragraph 14 of the ISME case in 2016, that the criminal case and the fraud that has been categorized as non-arbitrable, my lord. And before that, my lord, that complaint, the copy of the complaint case and the title suit, the plaint of the title suit, that has to be placed before this court, my lord. And one document they have filed along with this application, my lord, that is apparently false document.
Yes, Mr. Sahib.
My lord, here, what's the point, my lord? I'm submitting, my lord. The firm's name is NRB Associates. They have formed a company, NRB Associates Private Limited, same name, my lord, and diverted of fund. That is the only, my lord, question. So whether there is a diversion or not, my lord, that can be really decided by the arbitrator, my lord. There is no question of allegation against fraud, my lord.
Both the proceeding pending, my lord, is a question.
That is not a question, my lord. That is another aspect of matter. So far money suit is concerned, my land can also, my lord, they have already received the copy of the withdrawal petition, my lord. We have already
let them withdraw.
This 15th is fixed, my lord. 15th is fixed. We shall withdraw that, my lord. That is not the question, my lord. Now,
but they are intended to proceed with the criminal.
Title suit they have withdrawn. They have also stated that, my lord. We have withdrawn it.
No, but their acceptance does not amount to withdrawal. You have to withdraw it.
My lord.
Service of copy on the other side,
yes,
will not amount to withdrawal of the suit.
No,
has to be a
that
order.
is fixed on 15th. That is why, my lord.
All right.
That is
now, what do you say with regard to the judgments pressed into service?
Well, that is a serious fraud, my lord. That is another aspect of matter, my lord.
But you have
that they came up with the affidavit, my lord, that the fraud alleged by them, this is not serious.
No. Yes, yes.
That affidavit may file, my lord.
What they have said, my lord, I'm submitting. Para 10, my lord. They have
our firm's name is NRB Associates, and they have formed a company, NRB Associates Private Limited, and they have diverted some fund. This is the only allegation, my lord. This is the only allegation, my lord.
And what is the dispute?
Dispute like, my lord, land is my land. My lord, for the purpose of, my lord, constructing a warehouse, we enter into a partnership firm, my lord. And we constructed the, my lord, that warehouse. And that was rented out to somebody else. My lord, the amount should come to the firm's, my lord, account. Because heavy loan has been taken from the bank. Now, my lord, they directed the party to deposit in NRB Associates Private Limited, my lord.
That is the issue.
That is the issue, my lord.
Money claim.
My lord.
The money claim.
Not money claim, my lord. Other issues are also there, my lord. Regarding partnership, my lord. Because now also they have again rented out it to somebody else, my lord, he, and
The only question, my lord, no ego problem, my lord.
agreement copy has not been given, my lord. Copy has not been given. So this is a matter which can be decided by the arbitrator, my lord. Because arbitration, they themselves say, my lord, in the reply to notice your losses may see.
I am respectfully submit one thing, my lord, with the consent of my senior friend.
Place the order of that withdrawals of the money suit.
And also, my lord, that the complaint case here.
Complaint case is different.
How could it differ in, my lord?
We'll examine it.
For fraud and all they have alleged. That cannot be run together. This is clear finding.
When do you want it?
On after vacation, my lord.
No, not after vacation, my lord. Before vacation.
Then you completed the argument. Half-heartedly, all the documents they have filed, my lord.
On 15th, it is there. I will do it, my lord.
No, 15th is a date fixed before the trial court.
Trial court, we shall withdraw that, my lord.
You withdraw it and place it.
Yes.
And also they placed, my lord, the complaint case.
I shall argue, my lord.
No, they have referred it. The complaint petition has not been filed, my lord. What is it?
You tell us which date should have.
My lord,
After vacation,
your
15th or 16th, my lord. I have difficulties, my lord, in this week.
Any date, my lord, before
After
vacation.
vacation.
It may be on 23rd, my lord.
I have a difficulties, my lord.
23rd.
15th or 16th, my lord. After vacation, my lord. Just reopening.
No, after vacation, this is a question for referring to the arbitrator. That's the only issue to be decided.
Yes.
So let us decide this issue.
Yes, my lord.
Why are you deferring it?
No, I am not deferring, my lord. My only submission is let all the materials be placed before either by them or by us, my lord. That the basic
Let it be on 18th.
Yes. Let it be on 18th. Yes.
And
No.
18th September.
My lord, it may be 23rd, my lord. 18th, I shall be.
or 17th, my lord.
On the 7th, I shall not be here.
That is the difficulty.
Therefore, let it be after the vacations.
After the
Come
vacation.
back with all the pleadings, whatever is there.
23rd, my lord.
We have also filed an affidavit, my lord.
Okay, 17th, my lord.
Huh?
17th. Okay. Oh, I don't know. 17th, my lord.
All right, 17th.
Well,
Please take it on 17th. As agreed to by the council.
Parties may be have a liberty to file any document, my lord. Meanwhile.
Parties are at liberty to file any relevant document that they write.
My lord. Grateful.
Yeah.